Hi, good morning, everyone. Welcome to this joint workshop with the California Public Utilities Commission and the Bureau of Indian Affairs. We're really pleased to see so many folks here today. We're going to have some brief opening comments from some of the state and federal officials. Before we do that, though, I want to turn over the podium to Secretary Christina Snyder-Ashari to provide a welcome and land acknowledgement to open the meeting.
Good morning, everyone. I'm Christina Snyder-Ashtari. I'm Mihil Kauna, people of the Westwater, and Makamo, people of the Salmon Hole, and I'm a member of the Dry Creek Rancheria Band of Pomo Indians. I'm not welcoming you to my homelands, but we weren't able to secure Chairman Tarango to do the same, so I'll be delivering their approved land acknowledgement here today. Typically, I'm not a huge fan of land acknowledgements, but I think everybody's here working toward the betterment of California Indian country, so I think it's a good time to do that because there's meaning behind us acknowledging and working towards the betterment of the first people of this state. The history of the Sacramento area and the people is rich in heritage, culture, and tradition. The area was and still is the tribal land of the Nishinan people. Sacramento was a gathering place for many local tribes who have lived throughout the Central Valley and the foothills for generations and were the original stewards of this land. We'd like to acknowledge the Southern Maidu people of the north, the Valley and Plains Miwok and Miwok peoples to the south of the American River, and the Patwin-Wintun peoples to the west of the Sacramento River. We would also like to honor the Wilton Rancheria, the only federally recognized tribe in Sacramento County. We acknowledge that we're standing on the tribal lands of Sacramento's indigenous people. As we collaborate here today, I ask that everyone here and joining us virtually think critically about how your organizations can do better to elevate California Native people throughout the state, understanding that our communities hold both a rich cultural heritage and centuries of historical trauma that communities continue to recover from. Yahui, thank you.
Thank you. We also have Amy Dutschke, the Director for the Pacific Region of the Bureau of Indian Affairs, who is joining us virtually, and I would like to turn over to Director Dutschke to make some opening comments this morning.
Good morning. I hope you can all hear me. I'm sorry not to be there in person today. I'm in the Central Valley for a few meetings that I have, but I'm happy to be able to join you this morning online. I want to thank Commissioner Houck and Tribal Secretary Snyder-Ashtari for joining me and us having these discussions concerning the need to do this kind of workshop and training to provide both tribes and public utilities across the state with information concerning right-of-ways and the requirements for right-of-ways as utilities cross Indian country throughout the state of California. So I think this might be the first of maybe more than one of these types of workshops that we'll have. It's great for the Bureau of Indian Affairs to be able to partner with the Public Utilities Commission and the state of California on these activities. And I look forward to doing some additional workshops with the group as necessary. I want to recognize Yvonne Rangel, who's there today on behalf of the Bureau of Indian Affairs. Originally, Kim Urian would have been there, but she's with me at some tribal meetings again in the Central Valley. So I apologize for not being there, but as we move forward, we're committed to assist and to work on these projects however we can be helpful. So again, thank you, Christina and Darcy, for being there and for working with us on this, this important work. Thanks again.
Thank you, Director Dutschke. I want to also recognize Commissioner Gallardo from the California Energy Commission and turn over to her for some opening comments.
Buenos dias. Good morning. I'm Noemi Gallardo, Commissioner at the California Energy Commission. Energy Commission is the agency that leads energy policy and planning for the state of California. Our mission is to get to an 100% clean energy future, which is a very ambitious goal, and we need partners for that. The tribes, California Native American tribes to be specific, have been excellent partners to us. We are very committed to continuing to work with tribes. Last year, we adopted a resolution on tribal energy sovereignty, and we're going to be advancing that work this year. And we also reached a major milestone about a month or so ago where we invested over $100 million in projects with tribes as partners. So we're really excited about all of that work, and we appreciate these types of opportunities to be able to learn more about what else we can do. And so I'm really grateful to Commissioner Houck for inviting me to this event, and it's such a pleasure to see so many friends and allies and partners out there. So looking forward to all that we have to learn today. Thank you so much.
Thank you, Commissioner Gallardo. Mr. Monroe?
Yes, good morning. I'm Mark Monroe, the Deputy Director for the Middle Mile Broadband Initiative. And so as the name suggests, I work with the Department of Technology, and as I hope everybody is tracking, we're in the process of, and spent the last 3 years, developing an up to 10,000-mile network that would really connect communities across the state, be able to provide a middle-mile broadband backbone. And so that's really kind of been our area of focus. We started out in 2021. We were allocated about $3.25 billion in federal funds to develop the network. And we started reaching out to the Bureau of Indian Affairs and have met with a number of tribes as we move, as we kind of develop this network across the state, and trying to be able to address concerns, but also provide the connectivity. When we look at a lot of the lands that are out there, these are the places we're trying to reach, and the opportunities, the educational and economic development opportunities that we are trying to support with this network. So, yeah, we're glad to be here, and glad to learn more and talk a bit about our experience.
Thank you. We also have, and forgive me if I mispronounce, Nayla Pope-Hardin, the Deputy Director for Equity and Tribal Affairs at Caltrans, is also joining us this morning.
Thank you, no worries, I'm pretty used to it. Good morning, everyone. Nayla Pope-Hardin. As stated, I am the Deputy Director of Equity and Tribal Affairs at Caltrans. This position is a newly minted office in Caltrans. Part of the reason is to show just how committed Caltrans is to making sure that we are building relationships and elevating tribal issues at a leadership level. I've been in the job for about 3 months. I do not know many of you in the room, but I look forward to building relationships with you all around these issues. Thank you.
Thank you. And again, I'm Darcy Houck, one of the 5 commissioners at the Public Utilities Commission, and I really appreciate everyone here at the dais, particularly Secretary Snyder Ashari and our virtual dais director, Dutchke, for being supportive and helping to get in joining and partnering with us for today's workshop. The PUC has an open rulemaking regarding reexamining our tribal policies, our tribal consultation policy, and our tribal land transfer policy. And as part of that proceeding, we've been doing consultations around the state. And over and over, the issue of right-of-ways has been raised. Our agency regulates the investor-owned utilities, and we have oversight for telecommunications funding and certificates of public necessity and convenience. So we felt it was really important to have a conversation to get government agencies, tribes, and investor-owned utilities in the same room to open a dialogue and start talking to see where there are issues, highlight positive interactions, and highlight areas where we need to have improvement. And again, really appreciate the support and partnership from Director Dutschke on this issue. And as she said, we are welcome to work in coordination with the BIA to help facilitate additional conversations and in coordination with Secretary Snyder Ashari. And again, really appreciate her support and the governor's support on recognizing that we need to be engaging better and doing more to raise issues and address where we can. And so again, I just want to welcome everyone here this morning. I also want to recognize that we have several representatives from other state agencies in the office. We have Director of the Office of Energy Infrastructure and Safety. We have the tribal liaison from DWR. I don't know if you want to wave in case people want to connect with you. I think most people know who some of you are. Any other government agency representatives in the room from agencies that haven't been identified so far?
Commissioner, if I may, I
Yes.
would like to draw attention to Shannon Martin Guzman and Mackenzie Shea. Shannon is our project delivery manager on the Middle Mile Broadband Initiative. This has done a lot of the direct work between Caltrans and the Bureau of Indian Affairs and a lot of the permitting work. So at some point I might invite them up there to talk, but I just wanted to identify them.
No, great, thank you. And we've got a lot of staff here from the California Public Utilities Commission. And again, I'm just really pleased to see the turnout that we have both in the room and virtually. Look forward to this being an initial discussion that hopefully will facilitate further discussions, and look forward to hearing from all of our panelists this morning. And with that, I want to turn it over to my Deputy Chief of Staff, Amanda Singh, who will provide some logistical information and get us started on our first panel. Before I turn it over to Amanda, though, I did want to just see if Secretary Ashari wanted to make any additional opening comments.
I'm trying to keep it short. You heard me just have a coughing fit. I'm getting over a cold. It's not COVID. I've tested. It's fine. You're all fine. It's just turned into a dry cough, and now I'm losing my voice. So really appreciate the invitation and really looking forward to this conversation. I think what we've been trying to do in the Newsom administration is really take a look at the state of affairs in California right now and see where there's legacies of inequity and of historical injustices for California tribes. And so really having this workshop hosted by Commissioner Houck in partnership with Director Dutschke, I think is a step in the right direction of us really re-examining things that were put into place without any thought or consultation with tribes, and thinking about how we can pave a new future in partnership and collaboration and respect. So really appreciate and looking forward to the conversation today.
Thank you, and I'll turn it over to Amanda.
Thank you so much, Commissioner, and thank you everyone for being here. We have a great turnout. As Commissioner Houck mentioned, my name is Amanda Singh Birmingham. I am her Deputy Chief of Staff. I just wanted to really quickly go over some logistics for the remote attendees. We have 90 attendees that are remote today and that are muted. So these are some of the logistics. We will have 3 panel sessions today that will be followed by a Q&A session. So we'll be taking questions both in the room and online. And so I will be monitoring the Q&A function. There's a mute and unmute button and a chat and a Q&A button on WebEx. So I just wanted to really quickly go over that for our remote attendees to make sure that everyone can be heard. And here's our agenda for today. We are first going to open our workshop with the federal and state agency presentations and panel. Then we will go to the tribal representatives presentations and panel. We'll take about an hour lunch break, and then we will come back for our third panel for the energy utilities and telecommunications providers panel. We'll then have an open general Q&A session for an hour, and then we will conclude the public portion of the workshop. We'll take a little bit of a break, and then we will have government-to-government consultation. So we will invite any tribal representatives, tribal government representatives to stay, as well as federal and state agency representatives for this portion of the workshop. And with that, We already did the opening remarks, so we can move to the state and federal agency presentations. So first, we have our esteemed panelist, Yvonne Rangel. She is a realty officer from the Southern California Agency of the Bureau of Indian Affairs, U.S. Department of the Interior. So I will pass it to Yvonne now. Big button.
Is the clicker? Okay. Hi, good morning. Can everybody hear me in the back? Okay, perfect. Good morning, everyone. And again, I'd like to thank everybody for attending and welcome you to the Joint State and Federal Right-of-Way Workshop. As Amanda mentioned, my name is Yvonne Rangel, and I am the Realty Officer for the Bureau of Indian Affairs Southern California Agency. And today I'm going to be discussing rights-of-way across Indian land and going over the BIA right-of-way process. Okay. The BIA has 12 regional offices in the U.S., with the state of California falling under the jurisdiction of the Pacific region. Our regional office is headed by Amy Dutschke, our regional director, who gave an introduction this morning. And her office is located in Sacramento, California. We have 4 agencies throughout the state that can be seen here on my slide. Starting from the bottom, I have the Southern California Agency. Within Southern California, we also have the Palm Springs Agency that provides services directly to the Agua Caliente tribe. We have the Central California Agency, which you can see outlined in blue. And then to the north in red, we have our Northern California Agency. These 4 agencies make up the Pacific region and provide program services to our federally recognized tribes and our individual Indians in the state. Rights of way fall under the program of real estate services. Also listed on this slide are the realty officers that are located in these agency offices. Before getting into the regulations and going over the right-of-way process, I just want to make sure that all the utilities are aware that when we talk about reservations or trust land, there are 2 types of landowners that can provide consent to a right-of-way. First, we have the tribe. The tribe would provide consent to a right-of-way on tribal lands. We do have some reservations that are all tribally owned and consist of nothing but tribal tracts. So when we talk about consent for a right-of-way, you're dealing with one landowner, which is the tribe, and they would be the ones to provide consent for a right-of-way on tribal lands. Now, we have some reservations that are all that have tribal tracts and allotments. And an allotment is a tract of land that may have multiple co-owners. Each co-owner owns an undivided interest in the allotment, meaning that they have an undivided ownership share in that tract of land. This share cannot be physically identified on the ground. This is because undivided interest does not equate to acreage. Allotted lands have been probated over the years, which have created further fractionation on these once solely owned tracts of land. And it's important to note that when you are applying for a right-of-way over allotted lands, you are usually dealing with multiple owners and negotiating with multiple people. Whereas on tribal lands, you are negotiating and communicating directly with one landowner, and that is the tribe. Also referenced under allotted lands, we have public domain allotments. We do have some PDAs located throughout the state, and these are parcels of land held in trust by the U.S. for individual Indians. PDAs are usually located near or adjacent to a reservation, but they are not affiliated with any specific reservation or tribe. Okay, so let's talk about rights of way. Rights of way over Indian land and a general overview of the BIA right of way process. So first of all, what is an easement? An easement is a legal right to go over or across tribal land, individually owned Indian land, or BIA land for a specific purpose. A right-of-way can be a public highway, a service road, a gas pipeline, a sewer pipeline, an electric transmission line, a cable line, and the list goes on and on. There is a part in our regulations at 169.5 that lists all of the rights-of-way that apply to our regulations at Part 169. But in any instance, title to the land remains vested to our Indian landowners. I want to mention that Part 169 does define rights of way and easements. So if a utility calls and references an easement, I know they're talking about a right of way. So 169 defines a right of way as an interest consisting of the right to use or control for a specific limited purpose land owned by another person. This still means that title remains vested to the Indian landowners. And that is because a right-of-way is a non-possessory interest in the land, and title does not pass to the grantee. The Secretary's granting of a right-of-way does not diminish to any extent the Indian tribe's jurisdiction over the land subject to the right-of-way. This does not include service line agreements, which I will go over later in my presentation. Okay, so our regulations at Part 169, to what lands does this part apply? Our regulations apply to Indian and BIA land. It does not apply to fee land or fee interests. The BIA will not negotiate, compensate, or calculate consent for fee interest owners, nor do we have jurisdiction over fee land, which you may refer to as private lands. The BIA will not condition its approval for a right-of-way across Indian land on the applicant having obtained a right-of-way from the owners of any fee interest. I do want to mention that the BIA does not keep records of any fee interest owners. And usually if I get a question for fee ownership, I direct them to the county with jurisdiction. Okay, so when is a right-of-way needed? A right-of-way is required when you want to cross over, under, or above Indian land, and if you are a person or legal entity that is not the owner of the land, an individual Indian that only owns a fractional interest in the land, or an Indian tribe or instrumentality of the tribe who owns a fractional interest in the land. When is a right-of-way not required? A right-of-way is not required if you are the landowner who owns 100% interest in the land, or if you're a parent or legal guardian of a minor who owns 100%, or if you are authorized to cross the land by a lease, permit, or service line agreement. A right-of-way is not required if you are an independent legal entity wholly owned and operated by the tribe who owns 100% interest in the land. It's important to note that tribal land assignments, tribe-specific authority, and other land use agreements are not subject to a right-of-way, are not subject to this part, and may not require a right-of-way. So this is a general flow chart of how to obtain a right-of-way. This is straight out of our right-of-way handbook and is also located on the BIA's website. It shows the preliminary process, the application requirements, and the post-grant process. And I will get a little more specific into most of the items that are listed in this flow chart. Permission to access the land and the right-of-way application. Once it has been determined that a right-of-way on Indian land is needed, the applicant must first obtain permission from the Indian landowner to access the land. BIA approval to access the land is not required. Access to the land may be needed by the applicant in preparing information that is required by the right-of-way application, such as for surveying purposes, conducting environmental assessments, or to conduct an appraisal. An applicant is responsible for initiating a request to obtain a right-of-way. The applicant can contact their local BIA office and request for landowner information. And upon written request, the BIA will provide the applicant with the names, addresses, and percentage of ownership interests so that that applicant can make contact with the Indian landowners directly. The BIA does have a letter of intent template available for applicants to request this access. The notice of intent letter is written notification to the landowner that you intend to apply for a right-of-way and wish to access the land. The notice of intent letter should be submitted with your official right-of-way application. It is important to note that consent given by the Indian landowner to access the land is not the landowner's consent for approval of the right-of-way. Their consent to access the land and consent to approval of the right-of-way are two completely different requirements. Their preliminary consent to access the land does not guarantee that they will consent to the right-of-way, nor does it bind them to provide consent for approval of the right-of-way later on in the process. So, the right-of-way application. The right-of-way application is a required document, and while there is no standard form, the BIA does have a template available that includes all of the information needed by the applicant to be identified in the application, and those items are listed here. They include the applicant's information, the tract or parcel affected by the right-of-way. This is usually where the utility would list the tribal tract or allotment number that is being traversed if it's known. You must identify the purpose of the right-of-way. the duration, which is the term of the right-of-way, how long will the right-of-way be, the ownership of any permanent improvements associated with the right-of-way. All of these items must be identified in the right-of-way application. If the right-of-way application template that we have is not being used, you just need to make sure that all these items identified are in your application document. Along with the right-of-way application, you have required supporting documentation. That list can be found at 169-102B, and it's also listed here. So what needs to be included with your right-of-way application is a meets and bounds legal description, a map of definite location. This means a survey plat signed by a licensed surveyor showing the location, size, and extent of the right-of-way, and the map must be tied to the public land survey system. We recommend submission of the legal description and the plat map in advance of the official right-of-way application. And that's because we submit these survey documents to our Bureau of Land Management Indian Land Surveyor, also known as the BILS. The BILS reviews all survey documents for right-of-way applications on Indian land in the Pacific region. And he has a very heavy workload. He is one person for the entire Pacific region for all 4 agencies. So we recommend that you submit those in advance so we can get those reviews in his queue. Okay, so aside from the plat map, you must also include bonds, insurance, or other securities that meet the requirements of 169-103. This requirement can be waived by the Indian landowners. You also need to include a copy of record of notice sent to the landowners. This is the notice of intent letter where you need to request or gain their consent to access the land. You must include the landowner consent form for the right-of-way. You must include a valuation if it is applicable. And if valuation is applicable, it's usually in the form of an appraisal. So an appraisal, when a utility knows that they need to have an appraisal completed to determine the fair market value, they will send the BIA agency office a project description. The project description will go to the Appraisal and Valuation Services Office, also known as the AVSO. The AVSO will provide a scope of work to the selected appraiser. The selected appraiser will then complete their appraisal and return that appraisal back to AVSO so that they can review it and ensure that it meets USPAP standards. But that's if an evaluation is applicable. Other documents that need to be supported include the corporate documents. The corporate documents includes information identifying the applicant's signing authority on the application, that the right-of-way will be enforceable against the applicant, and includes documentation that demonstrates that the legal entity is in good standing and authorized to conduct business in the state of California. Corporate documents that I usually or typically see in right-of-way submissions include a delegation of authority, the articles of incorporation or association, and a certificate of good standing from the state of California. Supporting documents also include NEPA review documents. NEPA review documents for a right-of-way application are reviewed by the BIA's Division of Environmental and Cultural Resource Management and Safety. DCRMS reviews all NEPA documents for a right-of-way submission. Upon their review, they will issue a NEPA compliance document that we will include in the right-of-way record. An important item to note that is not listed on this PowerPoint is a construction schedule. A construction schedule must be provided if permanent improvements are constructed. This is according to our regulation found at 169-105. A construction schedule usually lists the start and end dates of construction and a process for changing the schedule by mutual consent of the parties. This due diligence requirement must be submitted with the application again if permanent improvements are constructed. Failure to comply with this requirement is a violation of the grant and can lead to cancellation of the right-of-way. Okay, this is a sample of the BIA's right-of-way application. I just wanted to show you guys to see what it looks like. Again, it does identify the items that need to be included in an application, and it does list the required supporting documents, so you can somewhat use it as a checklist to ensure that all the documents that are required are here and listed in your application. At the bottom, you will see that the applicant that has the authority to sign on behalf of the utility will sign and date the application. Okay, consent requirements. Again, there are 2 different types of landowners. We have the tribe and individually owned Indian landowners, but first let's discuss consent from the tribe. Tribal consent is required for a right-of-way across tribal lands, and this type of consent can be provided by a tribal resolution, a letter from the tribe, or by a written agreement with the tribe. Their consent may impose restrictions and conditions which automatically become a part of the grant of right-of-way issued by the Bureau of Indian Affairs. Tribal consent is also required if the tribe owns a fractional interest in the allotment. No matter how small that interest may be, if a right-of-way traverses an allotment and the tribe owns an interest, their consent is also required. The BIA cannot consent on behalf of the tribe. Tribal consent for our individually owned lands. Majority consent is required for a right-of-way across individually owned land. To reach majority consent, you must obtain over 50% consent of the trust interest. This is not to be confused with obtaining consent from a majority of the landowners that are listed on title. The owners of the majority interest is calculated by adding the fractional or decimal interest amount that is received from each co-owner that provides their consent. The total amount must be over 50%. It cannot be equal to 50, it must be over. I also like to point out again that we do not calculate or include fee interest when calculating majority consent. Majority consent only includes trust interest ownership types. Individual consent may include a life estate. A life estate is an interest in the property held for the duration of somebody's life. And if there is a life estate on title, the applicant must get the consent of both the life tenant and the owners of the majority of the remainder interests. Life estates are listed on the title status report, also known as the TSR, as a special interest holder, and this is located at the end of Appendix B on the TSR. It's important to point out that life estates hold a beneficial interest type. This means that they can receive compensation from any monies generated on the allotment, and in this instance, it would be compensation for a right-of-way, while the remaindermen hold the title interest portion of the interest. This means that they can consent to the right-of-way, but all income received for right-of-way compensation would go to the life tenant. BIA may also provide consent on behalf of certain individuals, which are listed here. BIA can provide consent for individuals that are whereabouts unknown, that are estates. Estate accounts are deceased landowners whose heirs have not been determined through the probate process. BIA can provide consent to those identified as non-compos mentis, or those individuals that need assistance in making their own decisions. We can provide consent on behalf of orphan minors and on individuals who have given us a written power of attorney to consent to a right-of-way on their behalf. The BIA may grant a right-of-way without individual Indian landowner consent if all of the following that are listed here apply. And that includes if the owners are so numerous, it would be impractical to obtain a right-of-way. So numerous is defined as 50 or more landowners. That's a lot of people to obtain consent from. We can grant a right-of-way without landowner consent if the right-of-way will cause no substantial injury to the land or to any of the landowners, and if all the landowners are adequately compensated. BIA will provide 60-day notice of our intent to grant the right-of-way on their behalf and provide them with 30 days to object. Okay, the landowner consent form. Consent forms should include all terms negotiated by the applicant. I actually have a sample consent form that I will show you as I'm reading off what should be listed in the landowner consent form for those of you that are visual people. I know I'm one of them. Okay, so this is a sample landowner consent form that the BIA can also provide, and it's located on the BIA's website. So again, when an Indian landowner provides their consent form should include all of the terms requested by the applicant. That includes the landowner's information, their name, to include the allotment number, and their undivided interest amount. I say the allotment number because most times, most landowners own interest in more than one allotment. So you want to make sure that you're identifying they're providing consent for a specific allotment. The consent form should include the purpose of the right-of-way and the term. How long will the right-of-way be on the land? When we're talking about individually owned Indian land, there are max terms. For oil and gas, we have 20 years. For all other purposes, the max term is 50 years. However, we can consider different durations if it benefits the Indian landowner or if it's required by another federal agency, or if the tribe negotiates for a different duration and the right-of-way crosses both a tribal tract and an allotment. The consent form should also include the proposed compensation to be received for the right-of-way, if bonds and insurance will be provided or if it's going to be waived, if any future consent is needed for a right-of-way that is known or that the utility knows is going to be mortgaged. Waivers of any kind should be listed in the consent form. And again, this is a sample consent form that can be used both for tribal and allotted. I typically see this on allotted lands because, again, the tribal resolution is usually the document that the tribe provides, and all negotiated terms for a right-of-way are usually listed in that resolution. Consent requirements. Right-of-way compensation on tribal lands. The tribe can negotiate for any payment amount for compensation, and we will defer to the tribe and not require evaluation if the tribe states that they have negotiated an amount satisfactory to them, that they waive valuation, and that they determine this to be in their best interest. No periodic review for compensation or adjustments is required unless otherwise negotiated by the tribe. The tribe can make a written request to the Bureau of Indian Affairs to determine the fair market value of the right-of-way. But if the tribe does not waive compensation or valuation, we will require that the grantee pay fair market value based on evaluation. Compensation on individually owned Indian land. Compensation must not be less than fair market value unless certain conditions are met. Fair market value should be the starting point for negotiations. This can mean that if a landowner is provided with an appraisal, that doesn't mean that they need to accept the amount or the value that has been determined for the right-of-way. They can determine a higher amount, and the BIA will not establish a ceiling on the compensation amount. Forms of compensation can be both monetary and non-monetary. Monetary can include the value that's determined and imposed fees, while non-monetary is an alternative form of compensation and can be varying types of in-kind compensation, as long as we find it acceptable and determine that it's in the best interest of the Indian landowner. I've seen where consent is provided in lieu of the utility providing free Wi-Fi service to every member on the reservation. So compensation doesn't always come in the form of monetary. Okay. Compensation requirements continued, and then I'll go over some payment adjustments. So BIA may approve a right-of-way with nominal or less than fair market value if the grantee is utility cooperative or tribal utility program that provided a direct benefit to the land, or if the landowners waive their right to receive fair market rental and the BIA determines this to be in their best interest. To waive the fair market value requirement, 100% of the Indian landowners must submit a waiver to us in writing that they want to waive this requirement. Fair market value is required to be paid to any non-consenting landowner, to owners on whose behalf we have consented, or to owners on whose behalf we have granted without their consent. So although majority consent is needed for approval of the right-of-way, all those non-consenting landowners are still entitled to receive fair market value. With regards to payment terms, adjustments, review of compensation must occur every 5th year unless payment is a one-time lump sum. Say that 3 times really fast. Unless payment is a one-time lump sum, the right-of-way duration is less than 5 years, the grant provides for automatic adjustments, or the BIA determines that waiving this requirement is in their best interest. If compensation is a one-time sum payment, the grantee must make the payment by the date we grant the right-of-way. The BIA office will generate a payment invoice and provide it to the utility to submit their payment to the BIA lockbox, because no monies for right-of-way compensation should be sent directly to the agency. If we do receive this monies, it will be forwarded to the BIA lockbox. This is a sample of the application checklist, just to give you an idea of what the realty staff will be looking at when we receive your right-of-way submission. This is the checklist that I utilize, and it can help you to ensure that all of the required documents that are applicable to your application are submitted. This is also located on the BIA website. Okay, the application review process. Approval authority is delegated to the agency superintendents for approval of all rights-of-way. The application review process has a preliminary review of 10 days. Within 10 days of receiving your application, BIA staff will identify if the application is incomplete or if it's complete. If it is incomplete within 10 days, you will get a letter identifying the missing information or documentation in your package. But if your application is complete, you will get an acknowledgement letter within 10 days. And within, starting from the day the application is received, starts our regulatory timeframe, which is 60 days. The BIA has 60 days to review, approve, deny, or request for an extension of your right-of-way. If we request for an extension of review time, you will be notified in writing. And in my experience, review time is usually needed, let's just say NEPA compliance hasn't been completed. So what we do in the Southern California agency is we archive your packet, meaning I'll keep your packet on hold so you're not having to submit the whole thing all over again. And once that one document is needed, then we can review the packet that we have for approval. Overlapping rights of way. So, get my notes in order. The regulations for rights of way changed in 2016. This added a section to clarify when a new right-of-way is required for a new use within or overlapping an existing right-of-way. I hope not to lose any of you, but I'm going to try to explain this as simply as I can. So if you are a grantee and you're requesting for a new use of an existing right-of-way, you can amend your right-of-way if the new use is not within the same scope and does not require ground disturbance. However, if you are the grantee and your new use requires ground disturbance, you need to apply for a new right-of-way. The original grantee does not have the authority to grant a new right-of-way on Indian land. When I talk about additional surveys, consent, NEPA, bonding, and compensation, that can go towards an amendment, because an amendment is not just a document that you submit. It does require further review. Let's just say you're increasing your acreage. If you're increasing your acreage, you have an updated legal description. And as I mentioned before, our bills needs to review that legal description. So that's additional documentation that's needed for an amendment. If you are not the grantee, let's just say you're a brand new utility and you want to overlap somebody's right-of-way, you want to use a portion of their right-of-way, you can do so if you obtain the consent of the existing grantee. You will include this consent in your right-of-way submission. And the grantee cannot unreasonably withhold their consent as long as the proposed new right-of-way does not interfere with the use or purpose of their right-of-way. Trespass. When a right-of-way is constructed on Indian lands and the necessary consent and approval was not obtained, you are in trespass. When a right-of-way has expired and you continue to use the right-of-way, you are considered in trespass. Unless you are in good faith negotiations with the landowner, which typically we are provided notification when good faith negotiations are occurring, and the right-of-way expiration date is usually known by the BIA office. Consequences of a trespass are subject to jurisdiction of tribal court and or the United States Department of Justice. Okay, so service line agreements. This is another part of the right-of-way. As I mentioned, a service line is not a right-of-way. A service line is a utility line connecting to the main line, transmission line, or distribution line that is used for supplying service to one house, business, or other structure. The agreement itself is between the utility provider and the landowner or the authorized occupant for the purpose of providing utility service to that landowner or authorized occupant of one tract of tribal or individually owned Indian land. An authorized occupant can be somebody on an allotment who's not a landowner, who's authorized to be there because they have an approved residential lease on the allotment. Is a right-of-way required for a service line agreement? Yes. And when I say this, it's because a service line must branch off of a right-of-way. A right-of-way and a service line are two different things. The service line is not a right-of-way, but a right-of-way is needed because, as I mentioned, the line needs to branch off of an approved and valid right-of-way. What if the main line doesn't have a right-of-way or the right-of-way is expired? If the right-of-way is expired, you need to put in place the right-of-way before you can submit a service line agreement to branch off of that facility. A service line does not require valuation, nor does it require BIA approval, but it should be submitted to the BIA office within 30 days after execution. The service line should also include a plat or diagram showing the boundary of the track, the point of connection to the right-of-way, and it must include the signatures of the parties if it's on a separate sheet. The utility provider should not begin any work for construction of a service line until the BIA has received the agreement and ensures that it meets all of the regulatory requirements of a service line agreement. With the regulation change in 2016, service line agreements are now required to be recorded in our Land Titles and Records Office. This means that it now shows up on the title status report, which is nice because it is an encumbrance on title. Here is a sample of a service line agreement that can also be obtained from the BIA website. And on the right, we have an example of a plat map. You can see the boundaries, and in that little cloud-looking thing, the utility has provided the BIA right-of-way number that this service line is branching off of. To the bottom right, you can see two signatures. Those are the signatures of the utility provider and the landowner, which in this instance is the tribe. Additional information, as I mentioned, all of these templates and checklists and forms can be found on the BIA's website at www.bia.gov. Do we have time for questions?
Oh, thank you.
Okay.
So you'll sit here.
Oh, okay. Grab my water.
Thank you so much, Yvonne. Wonderful presentation. And now we will move to our next speaker, Mike. Come on up. Mike Rogier from the CPUC's Energy Division will now be giving a presentation on infrastructure permitting. And you'll just press this button and go forward, okay?
Okay, thank you.
And then after you're done, please sit here.
I will. Okay. Thank you. Good morning, everyone. Thanks for joining the workshop today. I've already learned a lot from Yvonne's presentation. I work for the infrastructure permitting branch of the Energy Division. We support the commission in the permitting of infrastructure. I want to preface this presentation by acknowledging that we're not experts on permitting in Indian country, but we do want to be the best we can be in Indian country. And so this presentation is generally oriented towards private land, but it will provide an overview of how we permit infrastructure in various types of right-of-way. Yvonne went over the definition of an easement, so I'll be very brief here. And it's an easement is a non-possessory property interest, so it allows it's an agreement with the property owner, the fee owner, to use land for certain purposes. The easement is generally perpetual, so it will follow it'll be permanent on the land, even if the fee title to the property changes hands. Under an easement agreement, the property owner still continues to own the land and has full rights to the land as long as the owner agrees to the terms of the easement and doesn't interfere with the easement agreement. For instance, if there's infrastructure within the easement, the property owner has to make sure that the infrastructure is not interfered with in any way. Okay, typical easement agreements with private landowners. The landowner sells the easement to, say, a utility for a negotiated amount of money. The contract specifies the restrictions on both the utility and the landowner's use of the land and specifies the rights of the utility. It is binding on both parties and perpetual unless dissolved. In private land deals, when negotiations break down, the utility has a right to eminent domain. That another term is condemnation. Utilities have been granted the right of eminent domain because it is in the public interest to provide safe and reliable electric service at a fair price. Definition of right-of-way. As a right-of-way is the corridor in which infrastructure is placed within an easement. So the right-of-way cannot exceed the boundaries of the easement. So it's typically for most projects, it's the right-of-way is linear in nature, and described as a corridor within which infrastructure is placed. The width depends on the type of infrastructure. For the high voltage lines, it's going to be wider because the engineering dictates that the high voltage lines have a certain amount of clearance from the ground and from each conductor for safety reasons. For telecommunications projects, the right-of-way will be much narrower. Overview types of right-of-way. Fee simple ownership, that's where the land is owned in fee. So there is no easement necessary because the use of the land has been acquired in fee by the utility in a purchase agreement. Fee owners can have the right to enter into easement agreements if as part of their fee simple ownership. Franchise agreements are contracts between the utility and local governments. The local governments grant generally public right-of-way along roads for the installation and maintenance of infrastructure. Agreements cover permitting procedures, notice requirements, insurance indemnification, and applicable costs, fees, or tax arrangements that would go to the city or county for that franchise agreement with the utility. We also have public utility or road widening easements. Oftentimes, these are arrangements that are in general plans for cities and counties where they have set aside easements for future road widening projects. So oftentimes when a road needs to be widened because the public utilities follow roads, they also have to be moved out into the new easement that has been set legally obtained. Okay, I'll talk briefly about our role at the CPUC in permitting electric infrastructure, and this also applies to, I'm going to talk specifically about our General Order 131D, which does pertain to electric infrastructure, but it broadly applies to all linear all linear infrastructure that we permit. We do have a separate gas general order now that pertains just to gas projects. So we'll talk about our general order 131D that outlines the rules and procedures for our permitting of electric infrastructure. So the rules for these are the rules for permitting of electric transmission and distribution lines, substations, and generation facilities 50 kV or above in capacity. Infrastructure below 50 kV is not permitted by the CPUC. It's not subject to our jurisdiction. Well, and our permitting requirements. We still have jurisdiction, but we do not. The utilities do not have to come to us for a permit to install or construct. So we have a certificate of public convenience and necessity, which is for projects that are 200 kV and above. This is our most strenuous permitting application process. We have the permit to construct process, which is for voltages between 50 and 200 kV. And then we have the tier 2 advice letter process for projects that are exempt from PTC requirements. So if a utility is claiming an exemption, they file a tier 2 advice letter with the Energy Division, and we review the advice letter to ascertain that the exemption actually applies. And so we use our independent judgment to verify the claimed exemption. So the GO 131D also has certain reporting requirements for electric public utilities. It provides the procedures for our review of projects, of certain projects approved by the Energy Commission, and it outlines protests and complaint procedures that the public can use to contact us. Recently, we've been undergoing a general order update for GO 131D. So pursuant to Senate Bill 529, GO 131D was revised to allow a utility to file an application for a permit to construct in lieu of a CPCN application. This only applies to projects that will be constructed in existing right-of-way. So if it involves acquisition of new right-of-way, the streamlining rule will not apply. So it provides an incentive for utilities to utilize existing right-of-ways where there's existing infrastructure and the environmental review concerns are less because it's already a disturbed area and has undergone previous environmental review for the initial infrastructure that was placed there. Certain transmission, 200 kV and above, power line, which power line is defines electric infrastructure that operates between 50 and 200 kV, and substation projects are exempt from PTC requirements. However, they must be noticed in compliance with GO 131D, Section 11B. So even if they're exempt, the utility cannot go ahead and construct it without noticing people in the area. So everybody within 300 feet of the project has to be noticed under our noticing requirements. We're currently in the process of adopting a new general order version by January 31, 2025. And this may involve more extensive changes to the general order to make it more clear, efficient, and consistent. Under GO 131D, we have exemptions that apply. That if the exemptions are accepted as being legitimate under our rules, then applications are not required. So the utility would be allowed to construct the infrastructure without a permit. And this lists some of our criteria. We don't really see criteria A very much. Power line facilities with an in-service date before 1996. But we see B a lot. That is the replacement of existing facilities with equivalent facilities. So when infrastructure ages and the utility just needs to replace conductor on existing structures or something similar, they can do that without a permit from us. C is a minor relocation of existing power line facilities. So if a county needs to widen a road, create or the state needs to widen a road, and that involves moving support structures of a few feet, that can be done without a permit to construct, provided it's in an existing easement. Placement of conversion of overhead to underground, that can be done without a permit. Placement of new conductor or insulators on supporting structures already built. So this is replacement of conductor. The wires themselves, sometimes they get old, then they need to be replaced. Structures are there. They're allowed to hang new conductor without a permit. Power line, the F, power lines to be replaced or constructed, which have undergone review pursuant to CPUC as part of a larger project. So for instance, say there's a new housing development. We see this a lot. And as part of the housing development, the environmental document that reviewed the development itself will also review the electric infrastructure that was planned to serve that new community, and that's usually done at the local level. And so we review that document, and if it accurately depicts the infrastructure and accurately identifies what's needed, we accept that as environmental review, and it exempts the project from permitting. So we have a couple more here. Power line facilities and existing road widening, setback easements, public utility easements. These are all designated easements that we will grant easements for we will grant exceptions for and from permitting if those easements exist. And then lastly, the construction of projects that are statutorily or categorically exempt from CPUC. There's a number of exempting criteria under CPUC that will serve to exempt projects. These rules generally mimic CPUC, so there's a lot of overlap there. There's always exceptions to the exemptions. So this is something we look at very carefully when we're reviewing claimed exemptions for for projects. So under CEQA guidelines section 15300.2, if there's a reasonable possibility that the activity may impact an environmental resource of hazardous or critical concern, that would be reason to not exempt the project. We have the cumulative impact of successive projects in the same type. That would be a reason. If there's evidence that is occurring, that would be a reason not to exempt the project and require an application. There's reasonable possibility that the activity will have a significant effect on the environment due to unusual circumstances. So there are situations where there's an unusual circumstance that nobody can foresee, but if it can't, but CEQA provides for that, and so does our general order. So if an argument can be made that an activity could reasonably have a significant effect, the utility would have to file an application for a permit. I mentioned the distribution level infrastructure that's under 50 kV requires no CPUC permits. So these are distribution level voltages. These are this is the infrastructure you see on almost every street, along every county road, and the utilities maintain and construct that without discretionary permits from us. It does, however, require utility compliance with local building standards, and we expect that the utilities will engage with local communities to make sure that it is that the local governance is aware, and it has no problems with the way it's being constructed and where. Let's see. We have our noticing requirements for infrastructure projects, and under the general order, a listing of government agencies with which the proposed route reviews have been undertaken, including a written request for a brief position statement by that agency. Listing shall include the Native American Heritage Commission, which shall constitute notice on California Indian Reservation tribal governments. So this is required of the utilities when they are proposing infrastructure. They have to make these notifications, not only with the NAHC, but with other agencies. We have our own tribal outreach procedures for PTC and CPCN applications. So we go to the NAHC for a list of project area tribes. Also, our permitting projects that are permitted automatically trigger CEQA. So we have a statutory requirement pursuant to AB 52, where tribes that are registered with the commission are consulted with on the project. They're sent a project description and an invitation to consult with us pursuant to AB 52. And then independent of that, we have our own consultation policy, where we have the discretion to consult with tribes as appropriate on any project. So I think that concludes my presentation. Okay. All right, I'll turn it over.
Thank you so much.
Okay, thanks.
Thank you so much, Mike. And now we will go to Shannon Martin Guzman from the California Department of Technology. The big button will make it go.
That's perfect timing. All right, well, good morning, everybody. Today, I'll be providing an overview of some of the activities and efforts that MMBI, the Middle Mile Broadband Initiative Program, has taken to ensure tribes are appropriately compensated and that we are engaging with allottees as described in statute and regulations to obtain the right-of-way. All right, so Senate Bill 156 was signed into law in July of 2021 to create an open access middle mile network to bring high-speed internet to all Californians, with the tribes being a focus and target audience that we want to ensure that we get connectivity to. The map on the right provides an overview of the 10,000 mile map of the middle mile broadband network. And as you can see, we're touching just about every region of the state and traversing through a lot of tribal lands, especially in the Northern and Southern California areas. The table represents the current program mileage based on delivery type, all of which traverse through tribal lands in some form or fashion. As you can see, we have over 3,400 miles in leases. Those are where we are partnering with private entities. We have 435 miles that we are purchasing. This is our digital 395 route along the southeast portion of the state, over 2,600 miles in joint builds and 4,000 miles that Caltrans will be delivering via job order contracts, which brings our total to over 10,000 miles. Next, I want to give an overview of our tribal policy. This is going to be leveraged when we are working with tribal land, and it is a non-monetary form of compensation. The MMBI developed a baseline offer as a tribal policy for each of the tribes whose lands the middle mile network will cross. In exchange of right-of-way, Middle Mile Broadband is offering dark fiber and lit services. 6 dark fiber strands to the nearest 2 diverse huts and 2 unique diverse 10 gigabit circuits with dedicated internet access. The terms of the tribal policy will be a right-of-way to be granted for 50-year terms with 2 25-year successive renewal periods with right to assign, pledge, or mortgage all or any portion of the right-of-way or hut leases. Of course, this tribal policy is not does not come into effect until the tribe approves the policy via a tribal council resolution. And just to give you a sense of what that tribal policy looked like, so this is a visual representation of the tribal policy. I think it's very straightforward. You guys all understand this, right? Okay, all right. No, just to talk you through it a little bit. So on the left and the right-hand side, you see the visuals that have kind of look like homes. Those are our hubs within the program. Those are going to be placed every 50 miles along the 10,000 mile network. And this allows us to amplify signals and gives us a hub where the fiber will be housed. So from the hubs, we have fiber coming out through the hubs and to that middle vault that you see right there. That will be the vault where a tribal entity will be able to connect into the middle mile infrastructure. From that vault, the fiber strands that will be dedicated to the tribal entity will go to a Meet Me vault that is right in the center right there. From that Meet Me vault, the tribe will have the ability to either dedicate the fiber strands to say a tribal municipal network, or they can use those strands to get fiber to the homes within the communities. All right. And then for non-tribal lands where we have allottees, The MMBI has, the program has developed a process where we are engaging directly with Bureau of Indian Affairs, tribes, AVSO, and they all have unique specific roles in this process. The initial engagement starts with the Department of Transportation, Caltrans, and they collaborate directly with Bureau of Indian Affairs and Tribes to validate the property lines and landowners on tribal lands, which would in turn trigger the letter of intent. So if some of you may have received some correspondence from Caltrans, Caltrans is representing CDT as our authorized agent, so you may have received letters of intent on behalf of the Middle Mile Broadband Initiative. Upon execution of the letter of intent, which means it was, of course, signed by both parties, Caltrans will start the surveys, develop NEPA package, and engage CDT to start the appraisal services. Once the appraiser is engaged, AVSO will then work directly with the appraisers to develop the scope of work with the approval appraisal upon completion going to BIA for approval. Negotiations will then follow. If terms are agreed upon, the final package will go to BIA for the 60-day review period. And if all documentation is submitted appropriately, the grant right away is then issued. All right, that's literally a 10,000-foot overview of the process. I know that Yvonne got into much more in detail earlier, but this is mostly focused on the Middle Mile Broadband Initiative component. And that concludes my presentation for today. Thank you.
Great job. All right, and last but certainly not least, we will have Renee Fletcher and Sri Balasubramanian from Caltrans.
I just call him Sri. I don't even try.
Okay, so to move the slides, you just press the big button and it'll advance, okay?
All right.
I'll give you a mic.
Oh, okay. So good morning. Really happy to be here. I'm Renee Fletcher. I'm a Deputy Division Chief with Right-of-Way and Land Surveys in headquarters Sacramento. I've been a right-of-way professional for 30 years, but I do want to recognize my powerhouse. I know they don't want me to, but I couldn't do what I do without them. And I know all of you have those people. So Tiara Mooring, she's the deputy over utility relocation and railroad coordination. Denise Blakely, she's the office chief for utilities. And then Jean Marie Hunter, she's the office chief for project delivery. And that's over the acquisition federal tribal land. So again, I want to recognize them for being here with us. Again, also, I love going at the end because there's so many robust presentations that mine's going to be really easy. Yeah, thank you, Yvonne, for going through the entire process. That was really helpful, and I kind of knew that ahead of time. So for a transportation project, Caltrans, we follow the Department of Interior regulations as it's described in 25 CFR 169. And Yvonne went through the entire process of the application process. So Caltrans follows that in our manuals and in our negotiations. That's what we do. We get a grant of right-of-way from the Bureau of Indian Affairs for highway use, or if it's non-BIA tribal lands, we would get, the negotiation would occur directly with the tribe for a highway easement. So that's kind of the big picture. That's how we start, because obviously we need to build a transportation facility. Now, when the utility companies come in and want to use part of our highway easement, the utility infrastructure, we recognize, along with BIA, that utility is of a different use. So we can't just say, oh yeah, come on in and share our space. We recognize that the utility has their own specific use, and therefore they also need to follow the application process through BIA. Now, when the utility comes in, because they are sharing the same highway area, we go through the encroachment permit process, and that's where Sri comes in. So he will share that.
Thank you, Renee.
Yeah.
Good morning, everyone. My name is Sri Balasubramanian. I am the Deputy Division Chief for Traffic Operations. And one of the areas that my group covers is encroachment permits. So whenever anybody, Renee and her team get us the right-of-way and we put our highway, but then whenever anybody gets on the right-of-way that is not working on transportation projects that we let out as part of our contracts, they need to come in as an encroachment permit. And that's where Caltrans issues encroachment permits for any work that is done within the highway right-of-way limits. We have utilities that are mainly coming into our right-of-way because it's one owner dealing with one person or one group that does for entire 15,000 miles, central line miles that we have for Caltrans. Other things they come for is they want to put a driveway to have access to our right-of-way. Sometimes people come to collect seeds, but again, that's done under a permit. It's called a consent letter, but you have to get a permit before you enter the property. Encroachment permit is revocable, meaning if something doesn't work out, we can cancel it. It's only for a temporary purpose. It's not for a permanent right. Nobody can get land through encroachment permit. So we give it only for the time they come in, build something, and then they leave. If for utilities, they get to stay there for a long time, and they do that under an annual maintenance encroachment permit. So it's, again, they still need to have a permit. Without a permit, they cannot come in. Caltrans encroachment permit is not transferable. So if we give it to a particular utility company, it belongs to that utility company. They cannot give it up to anybody else. So if somebody else wants to come in or they want to exchange, the utility wants to exchange it from one utility to another, they still have to come and get a new permit from us. Encroachment permit, why do we do that? Because encroachment permit, we review it when we get it primarily for impacts to the highway operations. The safety of the highway operations is on us. So whenever somebody comes in, we want to make sure that the traveling public, any Caltrans team members that are working there, or even the encroachment permit team members that are working there, we want to make sure that the environment is safe. So that's why they have to come to get a permit, and we'll give them conditions. How do you set up a lane closure? What kind of policies do you want to follow? When can you work, when you cannot work? Make sure it doesn't conflict with our work or our contractors' work. So we take into account all of those things to ensure traffic safety and the safety of the workers that are out there. And then we also make sure they comply with federal and state regulations. So anything that we issue a permit, we also ask the permittee to make sure that they get permissions from all the required agencies. So for example, the Coastal Commission, if they're working close to a coastal area, if they're working on a tribal land, they need to get the permission from the tribe that has ownership over that property. So we have to make sure, or they have to make sure, that they get all the permits that are required for them to be working on that property, including us, because we have the right-of-way to have the highway there. Our permit offices, we have Caltrans is divided into 12 districts across the state. Each district has a permit office, and the permit engineer, the district permit engineer, reviews the permit application. Then we make sure we use our team, meaning our design, environmental folks, for them to take a look at the project work and make sure they meet all the requirements, and then we issue them a permit. But we also require the permittees to go and consult with all the necessary other entities, including the local tribal community. Most of the utilities, they've been in business for a long time, so they know who they need to contact in each district. So they go and talk to those people, make sure everybody is aware of what needs to be done, what the local conditions are, and they get their okay. And then we make sure that they get the okay. We also have Native American liaison and coordinators in each of our 12 districts, which they conduct the usual consultation with the local tribes, and they have a periodic meeting so that we are all on the same page. So again, it's a collaborative effort. What we do is issue permits for utilities to come and put their lines within our right-of-way. So with that, I'm done with my, my share of information.
Thank you so much.
Thank you to all of our presenters. And now we are going to transition to our tribal representative presentations and panel. We're going to have a longer Q&A session later this afternoon that'll include all the panelists from 2 to 3 p.m. So just want to note that now. So I invite Michelle Lee.
Amanda?
Yes.
I just wanted to actually see, I know there's a couple of people that may not be able to be here this afternoon to take maybe 2 questions. And I also just wanted to recognize all of the government agencies that are here today. We're in the process right now of having historic investment and build out in broadband, and we also know we need a grid that's going to meet the needs of the 21st century, which is going to require distribution and extensive distribution and transmission build out over the next several years. So the agencies that have presented this morning are the key agencies that are going to be involved in various approvals, whether that's for funding, right-of-ways, encroachment permits, and other things. So getting everyone in the same room and together, I think, is important. I also just wanted to point out a few folks that are here for tribal leaders and representatives if they have additional questions on the PUC's last mile. We've got our Deputy Director of Broadband, Maria Ellis, here. We also have our Deputy Director of Consumer Policy, Transportation, and Enforcement, Pat Sen, who's here, and our Tribal Advisor, Ken Holbrook, who's our lead contact for the PUC on tribal issues, as well as other folks in the audience, but wanted to recognize those folks. And again, that these agencies are the key folks looking at how we're going to get transmission and broadband built throughout California.
Thank you, Commissioner. Are there any questions in the room for any of our panelists? I have a microphone I can run to you. Okay. Yes. Here you go.
Regarding the Caltrans encroachment permits, so let's just say a communication line was on top of an electric line. You would have issued 2 encroachment permits. Is that correct?
That is correct.
Okay. And when you say that it is on that applicant to ensure that they get the authority to be on tribal lands, you still issue the permit prior to them getting a right-of-way on BIA land?
Afterwards.
Afterwards, okay.
Yeah. So usually what happens is when they apply for a permit, they have to come and show us that they've gotten permits from everybody involved in it. And so when they do that, we review that and say, okay, you've got all the permissions to be on that property, and then we'll issue them the encroachment permit.
Okay, so if somebody wanted to maybe get a listing of all the encroachment permits that you have issued on BIA land, is that something that you guys would provide?
Sure, we can provide that.
Okay, thank you.
I think also remember we have about 100 folks joining online, so if you could speak into the microphone when you're responding to, that'd be great.
Yes. And if there are any questions online, please enter them into the Q&A. They're now, the Q&A is now active. We'll give it another minute for folks to enter their questions online. In the meantime, any other questions in the room? Okay. Not seeing any. Any questions from the dais?
Okay.
Okay,
Thanks,
I think,
Amanda.
okay, of course. I think we're ready to go.
Actually, wait, there is.
I'm sorry, this might be a dumb question, but this is for Yvonne?
Yes, Yvonne.
Yvonne, okay, I'm just making sure I'm getting your name right. I was wondering if the 2016 regs, if they work retroactively, like for example, if there was an agreement that took place in like 1915 that said that it was going to be in perpetuity, does BIA re-examine those as well? Or are they grandfathered in?
I don't want to say no, that depends. Usually things are not retroactive, So if I'm looking at something that was approved way back when, we're going to look at the regulations that approved that grant. I'm assuming it's for a right-of-way. Well, we're going to look at the regulations that approved, or the authority that approved whatever that transaction is. I hope that answers the question.
So theoretically, if the holder of that right-of-way and the tribe came to the BIA and said, hey, we want to renegotiate this now that the times have changed, would you be able to do that?
If it's for, are we speaking about a right-of-way?
Right-of-way, yeah, sorry.
Yes, okay. So, yes, so an amendment can occur if something wanted to be changed. Any provision to the grants, or if acreage is being increased, or if acreage is being changed in any way, then it would be an amendment to that right-of-way. So, but when we're looking at amendment, we're looking at the regulations of today, even though that right-of-way was approved way back when. Okay.
Thank you for that question. We also actually have a question in the chat, and this question is for the CPUC. This is asked by Sid Morris. The question is, was there a consultation process with tribes regarding the CPUC decision to eliminate dual fuel systems on tribal lands? I'm not sure who would be able to answer that. Mike, there you are.
Could you repeat the question?
Yeah. Was there a consultation process with tribes for eliminating dual fuel systems on tribal lands? Do you know that?
I don't know that.
That's okay.
I don't have an answer.
We can follow up.
I'm not sure. Yeah.
I can respond. We are actually, we've just issued a scoping memo in that proceeding on the decarbonization, and we're re-looking at timeframes and exemptions on that determination. So we definitely would welcome and encourage tribal consultation on that issue and tribal comments in the proceeding. So that is still an open issue right now if there's any tribes that do want to meet with us on that.
All right, good morning, everybody. My name is Michelle Lee. I'm a member of the Pitt River Tribe. I'm also an attorney. I've been practicing in Indian law sphere for about 25 years, representing tribes across California. My comments today, my presentation is really more geared towards Northern California, so I'm glad we have a really balanced panel with North and South. But my experience is really driven from the North. A lot of, we weren't provided with the other presentations that occurred already prior to this, so a lot of my presentation I can skim through because it's already been covered, which is great because we want to catch up on some time. So yes, tribal trust land, we're talking about land that's held in trust. One thing that I want to add that from a tribal perspective that is important here is that the records for tribal trust land are maintained at the Land Title and Records Office with the Bureau of Indian Affairs. So when there's a document that's recorded, an easement, a right-of-way, or a service line agreement, it's recorded with the BIA. It's not recorded within the county, and sometimes that I deal with that with tribal clients where a utility wants to record an easement with the county and they completely overlook the fact that it's Indian land and the documents that need to be a specific form and that they are submitted to the Bureau of Indian Affairs and recorded in the Land Title and Records Office. So documents that are recorded with the county, I think I've heard different Bureau representatives say we don't have a problem with these documents being recorded with the county, but from the tribe's perspective, they're not really enforceable. They don't come up in any of our title documents, and so they don't really exist in our sphere. But one of the points that this panel I think will make is that there's been a lot of infrastructure, power lines, roads, all of these things have been installed and constructed and developed through tribal trust land, but there is not always proper documentation of that history. And that is what I think led to this whole conversation is that the tribal representatives and interfacing with utilities have discovered that there's a lot of infrastructure on tribal lands that's undocumented, and we need to cure that. So that's one of our goals here today. So you've already heard a lot about the right-of-way, what it is, and that it's an easement, and then there's a right-of-way within the easement, and there's an application process under the 25 CFR Part 169, and then there's some United States Code provisions that govern that. We also have the easement, and the easements are approved by the Bureau of Indian Affairs, and again, they're recorded within the Land Title and Records Office. And most of these easements are authorized by the Act of February 5th, 1948, 25 USC 323 through 328. And so there's this date, the 1948 year, there's pre-1948 rights of way, and then there's the post-1948. And I have see some nods, so I think Karen may address this a little bit in more detail. But I just want to point out that there's the pre-48 and post-48, and there's a difference. And then there's also another date in 1941, which I'll talk about in a second. Boy, this really slides slow. So the service line agreements, what those are, they stem from the right of way. So if you have a PG&E or a utility power line that had a right of way, and then there's service that's provided from that framework, then that would be through a service line agreement. Service line agreements are intended to be easier. They don't require all of the NEPA documentation, and they are supposed to be somewhat ministerial. But one problem I've encountered is that when a tribe has sought to have a service line agreement, they discover that there was never a right of way to begin with. And then we have to initiate a right of way. And of concern to tribes here is the time. The time is really important because many of these infrastructure projects are time sensitive. They are funding, there's funding that needs to be spent within a certain time frame. And when we have a reticent utility provider that doesn't understand the system, and now we thought we were going to get a service line agreement for an electric vehicle charger project, but now they've discovered there was no right of way. Now we have to do a right of way. We may miss our timelines for spending money, and we may miss opportunities for tax credits. So it's really important that we get a grip on what the situation is on the ground, so that we can have all the proper documentation in place, so that new developments with service lines and new infrastructure can be developed expeditiously. These are some really burning concerns for us in Indian country. So I mentioned that the rights of way and easements are recorded within the Land Title and Records Office. They're recorded on what's called a title status report. And many of you in here probably know this, but I think it's really important because I've found in my years representing tribes that a lot of the rights of way that are believed to be there, or service line agreements that are believed to be there, were never recorded on a title status report. And as a result, we face delays when we want to improve or expand that infrastructure. So the title status report, anyone doing in infrastructure with Indian tribes need to be very well versed in what a title status report is, and understand that that's your first step, is to determine if there is something on the title status report that you're going to be able to be connecting from, or if you have to start at the beginning. So that's one of my pet peeves, is we get into the development and nobody's looked at the TSR. And this is an example of what a TSR looks like. This is what I would call a clean TSR, meaning there's no easements or encumbrances listed on it. It has very, very, very basic information. You could have, I'm sure, at Morongo and at Hoopa, some of the panelists coming later, and at Rincon, where there'd be a lot of encumbrances on these TSRs. This one has none, but probably should. There probably should be some on this clean TSR. And the fact that there aren't any encumbrances recorded is actually a problem because it's blank. So I'm just here to set the table, and the tribal panelists are going to do the deep dive, but we have the TSR, the service line agreement, rights of way, and then we have the roadway easements, and it was good to hear from Caltrans. And when we get into roadway easements and who can go in the easement, that's when it gets kind of complicated, because often utilities think, well, we can just go in the Caltrans easement. It's already been done. And yeah, they can't. But they tell us that they can. And so it causes us to have to look at, okay, well, what kind of a road is this? When was it created? Because there is a difference between roads and the rights of way. So if you have one that was established prior to 1901 or under this 1901 statute, you're going to have a different set of rules than if it's a newer road. And I'll talk a little bit about that here. So when there's a right of way under the 1901 or the later 1941 statute, other utilities may go into those easements. But if it's post 1941, they can't necessarily. But either way, you need because of the rules and the overlapping easements, all new utilities need to have permission. And the scope of that permission and what is required is going to vary depending upon the underlying easement with Caltrans. So there may be situations where Caltrans does not have a valid easement on Indian land. They just may have a prior early easement that went under the early 1901 authorizations. And in that case, yes, Caltrans and the other utilities may go in it, but it's an overlapping easement, so you still need a utility to apply for their overlapping easement. So there's a 1941 statute that's important to determine whether Caltrans's original easement was a broad authorization or whether it doesn't fall under that and there's no authorization for others to go in. So even within the Caltrans universe, there is some legal rules. There's case law. It's something I'm still just learning about. I'm not an expert on it. I actually learned about it from Tom Schlosser, who is an expert on it. So we got to give credit where credit's due. There's a United States Supreme Court case that governs that whole topic, and it's United States versus Oklahoma. It's a power associate or road association or something like that. I'll get the citation. So of a concern to tribes is it is possible that the Caltrans doesn't have a valid recorded easement on the TSR. And so even though Caltrans is way far ahead of the other utilities in terms of having the infrastructure paperwork done, there's still gaps because the roads in California were created, most of them, especially county roads, were created on Indian trails. I mean, they started out as trails, right? The tribal people were using trails. There was a vast trail system across the state of California where we traded and we communicated and we had ceremony, and there were marriages and villages all along these trails. And then those became, as settlers came here, they became wagon trails. And then they became county roads. And then some of them became highways. And usually it's your less straight roads that are going to be those old Indian trails. And that's why it's so important for tribes when there's widening or any kind of work on the side of these roads that there be tribal monitors, because these roads are built to connect the villages, they connect our burial grounds, they connect our cultural places, and having monitoring is really important to Native people. And I see a lot of heads nodding. So yes, the county roads and Caltrans, I'm sure they have a consultation policy. But when others want to go in the easement, that raises a lot of red flags to the tribal people, because those roads contain cultural resources, and we don't want others to just be opening up the Caltrans easement without following the tribal consultation policy, which Caltrans has, and but these utilities may not understand. So it's important to determine what kind of an easement does Caltrans have? Is it on the TSR? What is the age of the easement? And are there cultural resources really that could be located along the easement, which is a different issue. So this is just a kind of a depiction, and it's got some weird highlighting in it, but it's saying that if it's 1901, then there's a certain process that it can be followed, and how can others go in it. And then if it's after the 1948 Act, you really get more into tribal and BIA involvement. But either way, in the pre-1901 area, tribes have a right to also have their own policies for coming through their lands. So there's a lot of layers here. Telecommunications and broadband, I'm not an expert at this, so I don't want to speak to it too much. I just want to point out that it's an issue. There's a right-of-way process that's a specific statute just for telecommunications, broadband, and fiber. And so broadband doesn't always just fall under the Caltrans easement. I think that's my main point I want to lay down here. And then in Northern California, we have PG&E. PG&E is our primary utility in Northern California, and there's 52 tribes that are in the PG&E service area. That's a lot. I think there might actually be more. I think there might be more than that. But these tribes have a lot of PG&E infrastructure that's there, and the infrastructure may not be recorded on the land's TSRs. And they're also, the infrastructure from PG&E may sometimes fall within the Caltrans easement, and sometimes it doesn't. And it may go in and out of the Caltrans easement. And the challenge there is that if you have poles that are in the easement and not in the easement, you're going to need to get the right of way. If you're going to be trying to string any kind of poles or add into the line, just straighten. This is a problem that is historic, and now we're needing to figure out how to fix it. And the way to fix it is to get every utility and every line on their own right of way recorded on the TSR, and that would be the way to go. And it's so small on this computer, I can't really read it very well, but there's all these easements, lots of kinds of easements. This wasn't even all of them, but all of these types of activity and infrastructure require an easement under the federal rules. So there's not necessarily exemptions where you don't need to have an easement, but there might be categorical exclusions, from NEPA, say it's already there. I mean, if it's already there, then it's a categorical exclusion from NEPA. Your NEPA document's going to be pretty short because you're not going to have an impact because it's already there. And so, I think utilities and folks new to this, maybe newer utilities, might be concerned like, oh no, this is going to completely blow our timeline. And what I would suggest is just start it. Just start it. The sooner you start it, the sooner we're done, because it really is just a process. And the process is one that's really well defined. BIA has a handbook. They have all the examples. They have templates for these documents. And if there's already infrastructure in place, as I said, you're going to potentially have NEPA exclusion because it's already there. So this is just the process in a nutshell. And it seems really overwhelming, but it's just steps that have to be done. And then there's a couple of questions that come up all the time for me. And one is like, who's the applicant? Because sometimes the tribe is the one that wants the service, right? And so it seems like the tribe would be the one applying for the right-of-way or the service line agreement, but it's not the tribe, it's the utility. So the utility is always going to be the applicant. The tribe can provide technical support. I mean, I'm happy to write up samples for you and advance the cause, but at the end of the day, it's the utility that has to submit the application to BIA, and they're going to be the ones interfacing with BIA. And then the other big question, so those are the two main questions that I seem to get, is who's the applicant, and then if compensation is required. And it is required for a right-of-way, but it can be waived. And so the appraisal and the compensation can be waived. And so a tribe, if it's to serve the tribe, obviously the tribe's not going to want to create another barrier. However, if the infrastructure's been there or it's coming through their lands and it's not really to serve the tribe, definitely compensation is required and expected. And that's a process that will involve an appraisal and a negotiation. And again, the sooner that process begins, the sooner the project's going to get done. And so I'm done, and I'm going to hand it over to Denise Turner-Walsh. And Denise Turner-Walsh is the Attorney General for the Rincon Band of Luiseño Indians. Is that still Luiseño Indians? Yes. Thanks, Denise. Thanks, everybody.
Thank you. Good morning. I'm Denise Turner-Walsh, and I am a member of the Rincon Band, and I've been serving as their Attorney General for about the last 12 years. And I'm just going to give you Rincon's perspective on right-of-way pre-1948, and then the issues we're dealing with today under the 1948 statutory framework. Let me see. So this picture behind me is a picture of the Rincon Reservation. It was established in 1875 by an executive order, and it was surveyed in 1891 under the Mission Indian Relief Act, and it serves as permanent homelands for the Rincon tribe. The reservation's approximately 5,000 acres. The large majority of the reservation is federal trust land. There are allotments, and about 3% of the land on the reservation is fee land owned by private non-Indian landowners. The reservation lands are in a high wildfire risk area, and the reservation sits on a valley floor that overlays an aquifer which is the sole source of water for the entire community, including all of the communities around the reservation. The tribal council of the tribe are 5 democratically elected members of the tribe. Our tribal population is about 500. And our tribal constitution vests all authority in the 5 leaders of the tribe, with 2 exceptions: rights of ways and land assignments. Those powers are reserved to the tribal membership. So when we grant a right-of-way at Rincon, we have our own tribal bureaucracy that we have to go through, in addition to the layers of federal bureaucracy and, in some cases, litigation. I'm going to start with what were the initial authorizations of rights of way at Rincon under the Mission Indian Relief Act of 1891. It authorized rights of ways. What you're seeing behind me is a picture of the San Luis Rey water basin, the watershed, through which the San Luis Rey River runs. And that is what recharges the aquifer and basically provides all of the water to the 5 reservations that you see on this map. Rincon's reservation is the brown picture. And what the Mission Indian Relief Act did was it allowed for rights of ways over these reservations in 1891. And very shortly after the act was passed, the Secretary of the Interior approved contracts, 3 contracts, 1894, 1914, and 1922, that approved rights of ways and licenses to non-Indians to impound the San Luis Rey River water at Lake Henshaw, which is the blue little blob you see on your right. And the impoundment of that water was approved by the secretary, and the Escondido Mutual Water Company and a man named William Henshaw, Lake Henshaw, built conveyance facilities. And these conveyance facilities started at the La Jolla Reservation, which you see in pink or salmon-colored orange, and the conveyance facilities and a hydroelectric plant at Rincon. Once they were all operational, basically diverted 90% of all of the San Luis Rey River water out of this basin to the cities of Escondido and Vista, which are to the south, and go through the purple area on the bottom of the map, which is the San Pascual Indian Reservation. So once these projects were built and operational, they traversed 3 of these reservations and took water away from the green and the blue areas, which are the Palma Indian Reservation and the Paula Indian Reservation, which is where the river would normally flow if it had not been diverted, and it would go out to the city of Oceanside and eventually to the Pacific Ocean. This is a picture of the Henshaw Dam. I'm standing pretty much on the dam, just taking this picture. I was just there like 3 or 4 months ago. And then you see to your right is a picture of what we call as the Escondido Canal. This is on the La Jolla Indian Reservation, and it's a few miles down from this dam. The ban, because 90% of the water was diverted by these secretarial approved rights-of-ways and licenses, the band in 1969, with other tribes, sued the city of Escondido and Escondido Mutual Water District for loss of the water. And they wanted to stop the diversion of the water. The 1972, we sued Vista Irrigation District, and the United States filed their own suit. These cases were consolidated. They went all the way to the Supreme Court. It took 15 years to go to the Supreme Court. There was a positive outcome of this litigation, which was that the Supreme Court said that the Federal Power Act authorizes FERC to issue licenses for hydroelectric facilities on Indian reservations, but those licenses are subject to any conditions that the Secretary puts on the licenses that are protective of the reservation. And Indian water rights really require that the reservation, the amount of water has to be there for the tribes for the purposes for which the reservation was created. So for domestic and irrigable use on the reservation, and what that quantity is depends on the size of the reservation and historical uses. The negative outcome of the Supreme Court case was that the Supreme Court basically said that the Federal Power Act of 1920 removes the consent requirement under the Mission Indian Relief Act. The Mission Indian Relief Act required the tribes to consent to those conveyance facilities that were permitted as long as there was consent and secretarial approval. The court said basically that Congress must have known what the Mission Indian Relief Act said, and in passing the 1920 Federal Power Act, must have intended for the Federal Power Act, which provided all of the hydroelectric kind of comprehensive plan for the West to deal with our water issues. They must have known that they were removing the consent requirement under the Mission Indian Relief Act. And the practical effect of this litigation on remand was to go back to the district court after 15 years and start the litigation all over again on remand, which the band did not, none of the tribes wanted to do. So they went to Congress and looked for a legislative fix, and they did find a friendly legislator and a friendly Congress at that time, and the San Luis Rey Settlement Act was passed to resolve these issues. The act required the parties to execute a settlement act that would come back to Congress and be federally blessed to resolve all of the controversies and claims. Once executed, it provided $30 million in payment to the tribes. There were 5 tribes at this time that were suing. Those are all 5 on that map that I showed you. The act established what we call the San Luis Rey Indian Water Authority. This is a federally blessed tribal entity that enjoys a trust relationship with the United States. They are now the land and water managers in the basin. And then the act was amended to find the water to put back in the basin. And that water was found from the lining of the Coachella branch of the All-American Canal in 2000. The act was further amended in 2015 and became finally in 2017. This took a 50-year process to settle the right-of-way issues at Rincon over water. Today, under the 1948 statutory framework for approving right-of-ways, the statute that Michelle mentioned, 25 USC 3232 328, it specifically preserves. So in 1948, they knew that they had all of these issues going on, right? They knew that we had not filed suit yet in the water litigation, but they knew that the Federal Power Act had been passed. There were other statutes that were operative that had basically authorized rights of ways through Indian country and all kinds of other lands. The general membership at Rincon, as I said, has to approve a right-of-way. And what happened at Rincon, what you're seeing is basically our right-of-way map today. And primarily, the only uses there are residential and commercial. We have a large gaming facility, and we have about 400 housing units. Those housing units, when they started to be built, was in the late 70s. At that time, we had a housing authority called the All Mission Indian Housing Authority, and they built about 85 homes on the reservation in a couple of subdivisions. But they also built homes outside of the subdivisions that were outside of a lease footprint, and none of these, only the homes inside of the lease footprint for the subdivisions had secretarial approved right-of-ways. So we have homes at Rincon that do not have approved right-of-ways. So this is getting back to the problem with the TSRs. Now, whether or not the TSRs reflect all of that at Rincon is just a whole nother can of worms, we have found out. But we have homes that are on, generation power. In order to run the homes, they have to have a generator because they don't have electrical service to their homes. And these are homes that are not as old as the homes that were built in the 1970s. These are newer homes that the band has developed since the initial housing development in the 70s that can't get electrical service because they don't have a right-of-way that's been approved to get the service line agreement to get the power to the homes. So we've got that problem going on. A lot of the problems where that exists, you've got general membership approval already. But what you don't have is you don't have SDG&E submission of the right-of-way application, and you don't have BIA approval because there's no right-of-way application that's been submitted. And then after that happens, there's a whole nother process to get the service line agreement in place. And all of this takes a lot of time. At every level, it's months for homeowners, honestly. And there are some homeowners that haven't had power for more than, 2 years, maybe more. This is also impacting the band's design for deployment of broadband because the poles on the reservation, the SDG&E facilities, we want to co-locate the broadband on the SDG&E facilities. So to the extent those facilities don't have approved right-of-ways, we're stuck there too. And like Michelle was saying, a lot of the money that's coming for broadband to Indian country is from NTIA and then also through the state. So it's time sensitive to get your work done. But we've got these basic issues that are making it kind of difficult. So what we've tried to do at Rincon is to understand the extent of this problem. I'm here with our housing director in the back, Cindy Ernst, who had to spend 3 days at the BIA Riverside office copying all of the Riverside office's right-of-way files. We took those files and hired surveyors, an army of professional land surveyors, to make us maps of the reservation to understand where we've got approved right-of-ways and where we don't, and overlaying our plan for broadband to be able to deal with both of the jurisdictional utilities, SDG in one case and AT&T in another. What we found out, which isn't surprising, is that the surveyors found that some of the files that were downloaded and given to them from the Bureau aren't accurate. Right-of-way file data doesn't match what's happening in the field. For an example, variations up to 10 feet of the center of right-of-way are not uncommon. And that's causing us to have to correct all of this stuff too. So, and the band has to bankroll this because there's just no other choice at this point. If we want to get on with these projects, we have to just understand the extent of the problem and then negotiate with our utility partners to come to some kind of resolution. And we, at this point, our summation of our problem is that SDG&E and the Bureau are under-resourced agencies. They don't have the staffing. The deficiencies are largely falling on tribal governments to fix this problem if they want to continue to provide electrical services and broadband services in the future, in their community. So I know we're going to hold questions for later, but that's Rincon's perspective right now and experience with the right-of-way issues. Thank you very much.
Okay, thanks, Denise. And our next panelist is Linnea Jackson. She's the General Manager for the Hoopa Valley Public Utilities District.
Good morning, everybody. Again, my name is Linnea Jackson. I'm the General Manager of Hoopa Valley Public Utilities. Can I get the presentation up? Oh. Big button. Yeah, one more. There you go. Perfect. Thank you. So just to explain a little bit about my background, I've worked for my tribe for the last 13 years. 8 of those was in Hoopa land management. So I have some experience with tribal environmental protection as well as the realty side. That experience has lent itself to my new job. So I have been the general manager for the last 5 years. So understanding the land status, the requirements for infrastructure projects is critical to facilitating these. So this is the Hoopa Valley Indian Reservation. It is the largest in the state of California. We just acquired 10,000 acres this past year, which is so we're over 100,000 acres in various land status. We are located in Humboldt County, which is the real Northern California. I'm glad that got a laugh. And Hoopa Public Utilities is a chartered tribal entity. We were established by tribal resolution over 42 years ago. We started off as providing domestic water services and irrigation. We've now expanded for solid waste management. We work in hand with the Indian Health Service for septic and water installations. We hire solid waste management, broadband, and energy. So that is a lot of hats to wear. It's all critical facilities that our reservation and our community members need. So with saying that, there needs to be partnership with every entity that I've heard from today. That's Caltrans, that's telephone, that's electric, that's CDT and the broadband. So we need to work in partnership and we need to make sure that policies are followed. So just a little bit about the land status maps. Yvonne, thank you for your detailed presentation of that. This is kind of known as the Hoopa Square. Again, you look at the different statuses. This happens to be the agency district, which is where I live. The different colors of the land constitute different land status. So if you're looking at developing an infrastructure project, one lot to the next could be fee property, tribal trust, allotment property, and then back. So to traverse over those, there's different requirements for each type of land depending where you're at. It creates a complex and very detailed process. So back in 2018, this is pre-COVID, the tribe did not have access to fiber projects. I was working at Hoopa Land Management at the time. There was a project funded by Scenic. And the awardee of this grant was operating on tribal lands for probably over a year, doing design, trying to install poles, not understanding the process for tribal consultation and tribal jurisdiction. So the green line kind of shows the area where they're traversing off of reservation lands into the reservation. And so I came in as the realty specialist, and to this company's credit, over the last 6 years, they have improved processes, which we all really need to do. So they had no understanding, and I do believe it's up to the funders to require jurisdiction. We all know, have access to FCC mapping now. We understand when you're crossing into tribal lands, and they need to understand really what that means. You're operating on a different tribal jurisdiction. There's processes that need to be followed, and tribal consultation is mandatory. So today, fast forwarding, we have 2 major fiber projects. We have an award from NTIA. We are doing fiber to the home. We're building communication towers, a data center, and the Hoopa Valley Tribe was the first tribe to enter into a joint build agreement with CDT for the middle mile broadband. So we are bringing regional connectivity. And pairing those 2 projects, you are working with different agencies from state, local, federal, bureau, all of those agencies to make sure that we are facilitating this project in a meaningful way. Again, to kind of talk about that really quick, sorry to go back. When our other presenters mentioned the timelines that are required for this, so we have an end date for our NTA project of July of 26, and CDT, we have to finish middle mile by the end of 2026. Those are hard deadlines, and so we need our partners to facilitate these in a timely manner as well, so that we're meeting and we're building resilient infrastructure for generations to come. So we talked about multiple coordination. In our area, we have to work with Humboldt County because of the county roads, the fee properties, Caltrans, Bureau of Indian Affairs, U.S. Forest Service. So when I talk about comprehensive consultation across the board, that's absolutely what it's going to take. I'm not going to go over we've all heard the right-of-way requirements, right? It's consent of the landowner, whether that's private individuals, whether that's the tribe, determining land status, ownership, appraisal requirements, compensation. We talked about where the TIPO might need to be involved in some of your projects. That's not just to check the box, letting them know about the project. It's also compensation for those services, for them to be on site when there's ground disturbance and to provide resources to compensate for those activities. So I wanted to talk about service line agreements a little bit. This is 2 water storage tanks that have been erected since November of 23. We are still waiting for electrification of this. And the reason why I say that is because everyone just experienced the extreme heat this past weekend. In Hoopa, it was over 110, 112 degrees. That is unhealthy, it's extreme, it's critical. So water demand is at its highest. So we have 200,000 gallon tanks. I submitted an application for service in 2022. The tribe has met all requirements for surveying, compensation, brushing activity so the line can be input. So it's not just tribes, it's also those providers that need to be held to timelines that don't happen. This isn't just a luxury. We're just not trying to, make sure we have one connection here. It's actually critical facilities. So instead of calling them out as issues, we are going to talk about areas for improvement. So we've all talked about the lack of recorded right-of-ways on tribal land. The first broadband project, when I talked about 2018, we entered into service line agreements when we're connecting those various tribal departments. When I tried to have those recorded at LTRO with the Bureau, they came back and said, we don't have a right of way to attach that service line agreement, and they sent those documents back. So poles that have existed for decades, again, are not properly recorded for various reasons. It's something that needs to be remedied. The joke amongst kind of my realm is that I've wanted to kind of Aaron Brockovich this process for over a decade, because how do we facilitate right-of-way projects and clear up title moving forward when companies continue to not respect tribal jurisdiction, understand tribal sovereignty, and adhere to those policies? So it's going to take enforcement from regulatory authorities, that being the CPUC. So it's requiring timelines for utilities to process applications for new service. We heard from Rincon how people have been without power for 2 years. I mean, in our area, we deal with energy resiliency issues, sometimes due to weather storms, EPSS, PSPS events. We have people that are without power. That comes into health and safety issues. It's a loss of food. It's the medical devices. It's access to communications. I do believe there needs to be CPUC penalties for not, meeting those timelines. The funding sources need to mandate that tribal jurisdiction and consultation has to happen. When we think about Caltrans's Dig Once policy, if we are doing 10,000 miles of broadband, it seems like if there's complementing projects, whether that be power, whether that be other infrastructure, that we pair those together as best as we can. So annual meetings, I think, would benefit everybody to bring state and local partnerships to see what projects are happening within the next 3 years. How can we use resources? How can we best develop this for the betterment of our state and community? And the people that are hired to be tribal liaisons working in those, I think there has to be mandatory training so you're understanding all of the requirements. It's complex. There's a lot of issues. Sometimes you're working with multiple jurisdictions, so understanding and having a comprehensive knowledge of that is absolutely mandatory. So don't assume that the processes that have happened since 1950 are what should happen now. There's no more status quo. So it requires respect of tribal sovereignty and jurisdiction, understanding where those boundaries hit, compensation for infrastructure on utilities for tribal lands, early consultation, and working coordination for the betterment of all. And that concludes, there's a lot more to talk about, but I guess in just ending, I would say that in order to do large-scale build-outs throughout the state of California, it's going to take all of us and a better understanding of tribal lands and how we can help each other work for the betterment of infrastructure. Thank you.
Yeah, she makes a great point. Many great points, but one of them is the staff within the utilities having training. And that's one of the biggest challenges that I think many of us face, is that you get one person at SDG&E or one person at PG&E and they understand the service line agreement and then they leave. And they retire, and then you get, and there's different people in different districts. So you could have somebody in the eastern part of Northern California that understands it, and then they're not able to work on a project in more of a western part of California. And so it becomes very hard to get these projects done. So key is to have training at the utilities so that we are not having to do as much of the work for them. So Karen, our final panelist is Karen Woodard, and she's the Realty Administrator at Morongo Band of Mission Indians. Thanks, Karen.
All right, good morning. Wow, that's some tough ladies to follow. Button, which one? Oh, this button.
Yeah, to advance, press that one.
Okay, okay. So Karen Woodard, I'm the Realty Administrator for the Morongo Band of Mission Indians. I've been with the tribe for 25 years. I was very involved in all of their land use planning, master planning, and from there just kind of involved in all of anything that touches realty, anything that touches land. So Morongo Reservation is located in Riverside County, California, one of the fastest growing counties in the county. Situated in the foot of the beautiful San Gorgonio and San Jacinto Mountains. We're about 35,000 acres, and we overlook the vistas of the San Gorgonio Pass. Some of you may be familiar with, so we're about 15 minutes west of Palm Springs and about an hour and a half east of LA. We have a rich cultural history in the historic Banning Pass area, dating back to the late 1800s. The area was a major hub of business for the railroads, agricultural, and retail. So we have rail lines, we have transmission corridors, we have everything that goes through Morongo. So we're well positioned on the I-10 corridor, so we have the I-10 freeway. We also have city of San Bernardino and Palm Springs, which is another, the I-10 freeway is a major corridor for tourists, commuters, goods movement, and large utility transmission lines, such as the gas, electric, and the broadband. Oh, I keep pushing the wrong button. This is a map of the reservation. We have tribal trust lands as well as we have allotted lands. So we have a residential community of about 1,300 acres. The rest is all tribal tracts. We also have individually fee-owned parcels within our allotted community, and the tribe does have fee-owned parcels. So as I said, the reservations comprise about 35,000 acre land area of approximately 54 square miles. Not nearly as large as Hoopa. I don't know how you do it, but it's a lot of work to manage all these tribal lands. Includes tribal trust lands, allotted, individual, tribally owned fee, Indian owned fee, and privately owned fee parcels. We have several right-of-ways with Southern California Edison, SoCalGas, T-Mobile, and Caltrans. Rights-of-way consist of major transmission lines and that provide services to Southern California, and distribution systems that provide services to our tribal enterprises, tribal members, and our housing and government facilities. So we have, like I said, about 1,350 acres. We have probably 600 homes. We have public works, our civic buildings. That's all the distribution system. We have gas transmission, large gas transmission lines. I think I have a map here. And we have the railroad. So and it might be a little hard for you guys to see, but on the top with the yellow lines, that's all the electrical transmission lines. And then we have the green is the gas transmission lines. Then you see the railroad. So a lot of right-of-ways that we had to maintain. A lot of these, when we talked about federal power acts, a lot of these were brought in back in the early 1900s, late 1800s, where the tribes really had no consent. It just came through, and a lot of them took that parcels in fee. We even have the Metropolitan Water District Aqueduct that actually runs through the reservation. So it's been difficult, and a lot of the records, because they were federal acts, may not have been at the Bureau of Indian Affairs, where they may not have been provided documentations to the tribe. Nobody, to be honest with you, they didn't care. They just wanted to get their power through, they wanted to get their water through, they needed homestead. They needed to do business to these counties. So Morongo, knowing that these right-of-ways were coming up for renewal, decided that nobody was going to push the fact that they had to come up for renewal, that we were going to seriously sit down, we were going to research every document that pertained to these, whether it was a federal act, whether it was, might have been a business committee way back when that may have approved it. So we decided we were going to just examine every document that we could from the tribal level, federal level, BIA level. And that brought up an issue that we were having with trying to understand what our land base was, what was involved in that land base, what our allotments have, who consented to what. So we decided there were some changes happening at the Bureau of Indian Affairs, so we decided that we would compact. We contracted in the beginning, and then we compacted all the programs and services from the Bureau of Indian Affairs. The reason we did that was for self-governance, and I'm really thirsty today, so I'm gonna grab my water. So we contracted all the programs, functions, and activities, including the realty and the title program. And that meant that we brought every record that pertained to Morongo onto the reservation, as well as we brought what they call the Department of Interior system, the Trust Asset and County Management System. That is actually housed at our Tribal Administration Building. And that tracks our government ownership, our encumbrances, we issue title status reports, we do all of that. So why do we decide to do that the compacting? We decided because we wanted to be self-governant. We wanted self-determination. It improved the understanding of our land assets and our records. It improved the tribe and the tribal member services. It improved land use and master planning. So the tribe got really involved in master planning their lands. We started master planning an overall general plan, got into master planning like certain corridors, and now we're getting more involved in the specific planning. And this helps us with the economic development. This helps us with our housing. This helps us negotiate these rights of ways. So when they come up for renewal, the tribe is prepared to negotiate what is the benefit to them, what is it the benefit to the utility, what's the benefit to the overall tribal goals and objectives for the future. So we do, like I said, it's title status reports, which is the ownership in the encumbrances. It certifies ownership, tells us what is actually on that property, on that tribal tract, and it has to be examined and verified. So a lot of times when you see a title status report and it says no realty records found, I'm going to tell you right now, there's a realty record there, but you've got to get in there and you've got to find out through the paper records, you've got to look at all of the history of that tract. Sometimes in TAMs, if there's a realty specialist perhaps working, or another title person that's working on opening a tract and working on certifying it, a road has been opened, this person issues a public TSR, it doesn't show up because the tract has been opened over here. Those are little things that I'm still complaining about with title. Whole nother discussion. So we do all kinds of realty transactions. We do mortgages. We do the residential leases. We do business leasing. We do land sales, gift deeds, partitions, and of course, service line agreements and rights of ways. Those are some major things that we do. We also do the recording of all of our documents that affect title. So this is kind of a flow of what a title status report process is like. So the request comes in, and I don't have my glasses, so I can't really read that. The ownership is verified, documents are pulled, documents are examined. We generally like 2 people to work on certifying a tract. We have someone examining the records, we have somebody doing the research. We never have the same person certify a title. That's a separate function. But we look at all of these documents, we pull all the paper records right back to microfiche to, rice paper, whatever it is. And then we certify the title from there. We also do surveying and mapping, which has really been a benefit for the tribe. There's been a lot, especially allotments, you get boundary issues, you get, that's my fence line, no, that's my, that water line's mine, that's, the utility's supposed to be on my tract, not on your tract. And it happens with the tribal tracts as well. There's a lot of trespass that happens. So we have surveyors, we have in-house surveying, so we survey all of our own tribal tracts, our allotments. We actually go behind, like Southern California Edison had some major transmission lines that they did some upgrades on west of Devers. We actually had our surveyors go out there with their surveyors just to make sure all the documentation was agreed upon and everybody had, verified that where these actually were located. Like I said, we do the boundary, the partitions, the rights of ways. We even do managed tracts. Utility mapping, roads, topography, and for our fee to trust transactions. We also provide other services for, we have our Environmental Protection Department, our Cultural Resources, Tribal Historic Preservation Office. So this is our monitoring program. We have monitoring agreements. We work with outside developers off reservation to put these agreements in place, work with the counties, with the local cities and that. We also have reservation services. We have our Public Works Department, our Water Department, sewer, and transportation. We have a lot of roads. We have that have been having to be mapped and rebuilt again over the years. Broadband as well. When we do partnership with Frontier, that's been working out really well to get broadband onto the reservation. And we also have government and community services. So we do have the same fiduciary responsibility as the BIA and adhere to the same code of federal regulations, Title 25, including Part 169, which is the rights of way. We also look at the BIA manuals, handbooks, their policy memorandas. We also contract with other tribes to assist in processing their realty and their title transactions. And we process this if we were the BIA, but we don't have the signing authority. We can't sign an actual grant of easement. We submit that to the Bureau of Indian Affairs for that. And then what happens is they pretty much go through the same process. If you look at the box that I marked here with the red around it, that's what the BIA does for us. We do everything else, and then we submit to Yvonne to approve our right-of-ways. She's been a great help, and I'm going to say the BIA is understaffed, overworked, just like everybody else. And people need to understand that these things take time. They take a lot of time, they take a lot of work, and when you only have 2, 3, 4 people that are working on these things, it's not going to happen overnight. And everybody needs to be patient, everybody needs to work together. But the BIA actually will review our documents to make sure that everything's in that package when we send it to them, and then issue the right-of-way approval or whatever it is else that we're looking for. And she's done some really big ones too. Southern California Gas. That was a 68 pages survey. It was large, and that had legal metes and bounds descriptions that we had to review. I felt sorry for the bill surveyor too. It was a lot of work. So on top of that, the tribe also has right-of-way ordinances. We passed Ordinance 26, which is a utility authority. It established the tribal utility authority on the Morongo Reservation to become its own utility. The ordinances define the policies and procedures of that authority, rules, regulations, and gives the authority to establish. I think it's an error. So that gives us the authority if the tribe decides that we want to become the utility and we want to provide services to our tribal membership or our tribal enterprises, that gives us the authority to start participating in that. Working with CAISO, working with the CPUC and all those types of regulations. We also established the Ordinance 31, which is the utility transmission, established the regulations and procedures for the submission and review and grant or denial of applications. For the issuance, renewal, or modification of licenses, easements, rights of ways, or other rights in and across, under, and upon the lands of the Morongo Indian Reservation. For the location, construction, operation, modification, maintenance, or replacement of electrical transmission lines, pipelines, or any kind of access roads, telecommunication facilities, pumping or booster stations, or any other utilities that are owned or operated by any person or entity other than the Morongo Band and Mission Indians. So in this, we established our own internal process. The utility issues us a letter of intent within 90 days prior to their submission to the application for the BIA. This establishes the contents of the notice, the purpose, description of the project, the timelines, the application contents, the copies of any environmental, economic, and other analysis that the applicant has performed in connection with the proposed project, detailed information identifying required alternative routings or locations for the project that the applicant has designated as such, copies of any economic or other justifications for the project, and that the applicant has submitted to any other governmental jurisdictions. It also asks for any copies of permits or certificates that the applicant already had attained from other governmental jurisdictions in connection with the project status of such applications, or if permits or certificates have been filed but not yet obtained. The status of each such permits or certificates must be described. So to the extent that the not already provided in response to number 3 above, or the bullet point I just had there, a specific analysis of potential impacts on the soil, water, and air for the Morongo Indian Reservation suitable for NEPA must be presented. We also request a forecasted 15-year utilization for all loads, capacities, or other services, uses of the facilities, including the associated economic forecast for the project. That helps us in negotiations. A proposed compensation plan for the granting of the proposed right-of-way. And we request all of this prior to going to the Bureau of Indian Affairs because we want to make the job easier for the Bureau of Indian Affairs. We want to get to, if it's something that's going to benefit the tribe, we want to get it done in a timely manner. Housing was a big thing before I got onto the reservation. There were no houses. There was very few houses. A lot of members lived off reservation. A lot of members wanted to come back to the reservation. So we were trying to establish processes for once that house was built, how quickly can we get the utility there? So like we were saying, sometimes a house sat there for 2 years. Nobody knew what the real right-of-way was. Did they go back to their government lands office and find the right-of-way? Could we do a service line agreement? So we ended up working with very, very closely with our local utilities, Southern California Edison and SoCal Gas, and we decided to try and find some resolution here, at least for our housing. I mean, there's no sense in a member living and paying rent outside of the reservation waiting for a house to get power. So we created a temporary access permit. And this temporary access permit allows us to move forward, gives the utility company the right to come in and construct, and then gives 7 years for us to prepare the right-of-way. So this asks for all the information pertinent to the applicant or to the individual or the tribe who's ever wanting to do the service line agreement or the right-of-way. So it has those types of information in there, as well as it has the purpose of it, if it's for housing, if it's a tribal enterprise, those types of things. And then it also has, we provide a map to it so that we can later come back to it. There's also an internal environmental process that we do for these service line agreements. So there's not an issue when it goes to the utility. So we do the smaller, a plat map showing where it's located at. And then we might do an aerial, let's see, we might do an aerial, we might want to show where the house is, those types of things, just so that when we go to do that right away, all of the documentation is still there. And that's really helped move housing projects along pretty quickly. Let's see, that is kind of slow. So other things to consider, and we've all talked about how important it is to collaborate and partnerships. And it's really, I'm really happy to see all of these people in this room because I was, 25 years ago, I am begging a utility company to assist me to get power to a house. And it was not a great time. So I'm just really, I really want to thank our CPUC and our CEC and everybody here that has decided to come together and collaborate on these things. And one of the things that I'm really going to, partnership is a big deal. I have worked for 25 years with Southern California Edison, and we have a great relationship. We have great tribal liaisons. We have planners that are dedicated to the reservation. So I don't just I file an application and it goes to whatever field office. We know who those planners are. We know who's to take that application, and we go directly to them. So it's not getting lost in the system. So those partnerships are really, really important to establish. We have utility planners, we have environmental and government land staff dedicated to the tribes. We're very fortunate that way. We do a lot of collaboration and researching and updating documentation. We have government lands offices within our utility companies that if I can't seem to find a document, we'll go to their lands office and ask them to look them up. So that's been very beneficial. And just establishing the communication between the tribe and the utility. Confirm the main points of contacts. Have regular meetings, have regular reporting. I meet regularly with our utility planners on a monthly basis, sometimes on a quarterly, depending on how the activities are. But we try to meet regularly to say, hey, we've got these 5 or 6 applications. What are we doing with them? Where are we at with this right-of-way process? And that's been very beneficial for us. And I think that's the end of mine. Thank you.
Yeah, I have a question for Karen before she gets away. So all of this takes funding. Does the contracting of the services give any federal funding back to the tribe because you're taking over that process, or is this wholly paid for by the tribe?
No, there is the tribal priority allocation dollars. So we do get funding from the Bureau of Indian Affairs. And it's not a lot of money. So the tribe does have to fund some of it, but the services that we've been able to provide our members and the tribe has just totally outweighed that. But yes, there is federal funding, like the compact tribes, they also participate. So it's, works out good that way.
That was a question maybe others would have too, because this all does take money, everything that Morongo's doing. So I'm just going to do a little wrap up and then open it up for if there's other questions. One thing that was present in all the presentations was about compensation. And I think we kind of dance around it a little bit, but compensation is really important, particularly if you're, these tribes where you have the rights of way passing through. And, unfortunately, Indian country, in the past, that's what happened is the rights of way went through Indian lands because they were, unoccupied a lot of the time in the past, or they were just easier to run it through the Indian land. And then today, many of those old rights of way are expired and need renewal. And at this point in time, compensation is really necessary. And I think highlighted here was the burden on the tribes, the cost of the tribes to straighten this all out. And compensation isn't just, to be paying this tribe for the use of the land. It's paying for the tribe for all of the loss of the use of the land, where the tribe has the lack of ability to use their land because that infrastructure's on your land for potentially in perpetuity. So renewals come up. Sometimes there's renewals that come up and the utility net doesn't realize that it came up, and then you're in trespass. And a negotiation is necessary to resolve the trespass because these are the rights of way they are not perpetual agreements. They do have a term, and the new term will most likely require compensation. We have many tribes in California, some say 110, some say 109, but it's a lot of tribes. Doesn't matter whether it's 109 or 110. I think it's just whether you include Arizona straddling tribe. But there's a lot of tribes, and so the idea of compensation for utilities may seem onerous, but this is really important compensation that goes back to historical reasons. And the tribes that showed their maps, they have very small land bases compared to what their Aboriginal territory is and was. And so imagine having all of your land taken and you're left with a small piece, and then it's now even that is cut up and you can't use the whole thing. So the compensation is historical in nature. It's not just for now, but it's for the past, and it's for the present loss of use, and it's for the future loss of use. And in other states, I've negotiated a right of way for a tribe in another state, and the compensation was like life-changing, substantial to the tribe, and also provided a point of presence that they could utilize. And so compensation is really important in this conversation, although the compensation can be waived when the tribe does need the service and they're trying to just build their infrastructure. So there's a lot of things that can be discussed there. I know TAMS was mentioned in this section and also earlier, and it was not in my initial slides, but it stands for the Trust Asset Accounting Management System. So the TAMS system works with the LTRO system and TAMS, and Yvonne will probably be able to explain this much better than me. I've never worked at the BIA, but I understand TAMS is the day-to-day input, and that's where the initial point of interface is with the Bureau of Indian Affairs and on land records is through TAMS. And it takes funding for tribes to be able to do this work and to monitor these efforts. And so this is a tremendous burden on the tribes when they have to pay lawyers and consultants to conduct this work, and it is very costly. But it is important because without doing this work, we have potentially no power and no utilities. So it's something that we have to do. Are there any questions in the room or?
Michelle, I have a question for this panel, and then also I'm probably going to ask the same question to the utility panel later today. But I think we heard a theme that tribes have had challenges in energizing projects, and we've got housing projects on the reservation that Rincon had mentioned. We've got housing projects and critical utility services on the Hoopa reservation. That in the PUC right now, as I think folks are aware, is very concerned about energization and the need to make sure as we're transitioning to a clean energy landscape that we're able to provide those electrification services so that we can decarbonize building and transportation. So this is obviously a critical issue we're looking at. It seems that there are additional challenges in being able to electrify homes and buildings and services on tribal land. Morongo sounds like they've made a lot of progress in regards to what they're doing on the reservation, but could any of the tribes maybe speak to some of the critical challenges that you're facing as part of the dialogue for the utilities to hear? And again, I'm probably going to ask this question to the utilities later, but how can we help bridge this gap to make sure that tribal communities aren't left behind and that they're able to move forward as we're looking at a clean energy transition?
So going back to kind of the conversation about there not being enough resources or staff members, I'll go ahead and preface that with, understanding that there's probably lack of staff. But our housing authority within Hoopa has had probably 15 to 20 applications waiting for energization for over 2 years. How do you proceed with that? How do you get your membership into critical homes when you can't have the homes electrified? The water storage tank that I mentioned, I wanted to preface that, and I forgot to mention this, is that we were one conversation away from losing the state match with the State Water Resources Control Board because we could not energize that tank, which still sits there unenergized. So it's also, there's one liaison for PG&E for, we mentioned over 50 tribes. That is absolutely not adequate. PG&E tends to be very siloed to where you have different compartmental that you don't know who to contact. And so with the tank project, I've reached out to everyone that I possibly could. I've sent over 30 emails letting them know that this is critical. I'm about to lose the state match on a $2 million project. Where are we going to get that funding from? And there seems to be no respect for those timelines or even understanding of how critical that could be. So there has to be additional staff. There has to be a way that, because I've looked into this personally, how do we submit a complaint to the CPUC as the regulatory authority, and then that process, do we become a party to one of your motions, hiring legal staff, that all takes resources. So I think understanding of a better process, because it's complex, how do you maneuver the legal world with that? HOOPA has one tribal attorney who handles everything from ICWA to tribal court to water rights. How do we utilize that? So there has to be a process and a way for tribes to be able to communicate. Again, with the IOUs, understanding that there's penalties for not meeting these timelines, just like there's a 90-day process for this. I mean, understandingly, a year is way too long, 2 years are way too long for something to sit dormant waiting for that service.
Yeah, and I could just echo on behalf of the different tribal clients that I've represented. They also are not able to get responses within the appropriate amounts of time. And, there's flood events where there was a tribal elder home that was flooded because of poor infrastructure that was installed by utility, and it flooded for many months this year. And despite repeated calls and like was said, there's only one tribal liaison in PG&E. He can't do it all, and he definitely isn't empowered to fix PG&E for Indian country. So we can't expect those changes to happen without a full evaluation of whether there could be a better communication process for the tribal communities that are in the PG&E service area, and maybe SDG&E as well. I'm not sure. There's different political environments within the state of California.
No, thank you. And I don't know, Denise, if you wanted to add anything as far as any improvements with communication with the IOUs or concerns regarding the process with BIA that's preventing the houses at Rincon to be.
Well, I just speak to the area that we're in, which is San Diego Gas and Electric. And, San Diego County has 18 federally recognized tribes. It's like a lot. But so does PG&E apparently. In their jurisdiction, they have over 50. But it is an under-resourced issue. We have recently, in the last maybe 4 or 5 years, had Jennifer Summers, who is the new tribal liaison at SDG&E, and they had been contracting out and are still contracting out right-of-way work to consultants, and then they hired another person in-house to do the right-of-way work, who's now on medical leave. So, it's an issue of training and adequate resources for the amount of their service area. I mean, I think that is what the commission could look at, that's within your wheelhouse, right? And as far as BIA goes, it's bills. I think that they're just so slow, it takes forever. And if those legal descriptions don't close, guess what? You're back at square one. Resubmitting because there's something wrong with the legal descriptions that they can't close the survey so that they can process the application. So, there's a couple of things, technical, and then there's resource issues. That's what I would say.
Thank you. And then I don't know if Karen wanted to add anything.
As she mentioned, the bill surveyor, there's federal agencies that don't have enough staffing. The bill surveyor, for instance, we've got one surveyor for the entire state, and he's got to review all of these maps, make sure that they all close properly. He's not just reviewing right-of-ways, he's reviewing partitions, he's reviewing feet of trust, he's reviewing all kinds of different land transactions that are taking place. So that's a real problem. Appraisals, that's going to be another problem. We don't have enough appraisers that want to work in Indian country. They don't want to go through that whole process of a fully self-contained appraisal report. It's trying to get a review of those appraisals. There's not enough appraisers in AVSO. So that's another concern the tribes are having as well. And that slows things down. You're adding 6 months, 8 months, 9 months to a project.
Okay. Does that answer your question, Commissioner Haupt?
Yes, no, I appreciate it. And I, again, see this as the beginning of a conversation, and hopefully we can continue to work through these issues. And just want to reiterate that energization is a top priority of the commission right now. And we want to make sure that we're engaging with tribes and getting input into the record in our proceedings on that.
So there's a question online. This is for the panelists, have you encountered problems with NTIA or other grantors considering tribal land, quote, already served for purposes of broadband grant funding where existing service is provided by internet service providers that lack rights of way? So are you getting any already served responses? Have you been able to challenge this determination or service maps?
I can only speak to my experience on that. So I can hands down say that Hoopa is considered unserved. There's no fiber connectivity. We have a 7-tower hop even just to get minimal internet service. We were able to self-certify that at the beginning as part of the funding. So that was accepted. But I do understand that not just in broadband, but there's companies that claim to service an area and provide services and claim that, but don't necessarily meet up to those guidelines. So, how is that justified? So I could see that being probably an overarching issue where companies are provided funding to provide service, which doesn't happen and trickle down to the community. So I'm sure that's a large issue.
Yeah, so if you have an internet service provider that doesn't have a right of way, and then when they go for a grant, it says you're already served, but there's none of the infrastructure in place. That seems like that's a possibility.
I definitely would challenge that. I would incorporate your own speed tests, provide backup data in different areas to be able to quantify that. And I would push that envelope as much as you could to show that the community isn't receiving adequate high-speed internet.
Michelle, I'm going to put Maria on the spot for a second. We just opened our challenge process for our BEAD program, which is NTIA funding, and part of our program requires there be a letter of consent and commitment from the tribe if anyone's proposing any kind of a project on tribal land. But I don't know, Maria, if you want to give a 30-second just let people know where they can get information if they do want to challenge anything on our maps for BEAD.
Absolutely. So Monday was the start of the official NTIA challenge process for the BEAD program, which is the Broadband Equity Access and Deployment Program. We are in a 120-day, we're starting a process of like a 120-day challenge process, which is the model challenge process. I can certainly, I'll send over a slide. I don't know, I'll send you a slide here and we can put it up here so folks can see directly some of the links and the timeline. One of the, to Ms. Jackson's comments, we do understand that there is, what is always sometimes represented on the maps is not a reality on the ground. And for tribal nations particularly, the data is just not good. And if you're starting from really bad data on that, it's really challenging to sometimes make the necessary corrections. For instance, the NTIA for the BEAD challenge process, you can't add BSLs, broadband serviceable locations, which is actually one of the big things that you would need in tribal nations is the ability to add these dots on the map. The NTIA rules don't allow for that. We can flip served to unserved or underserved, but those are really the parameters. But it's still important. It's still important, though, to go ahead and participate in these because it provides additional data to the federal government and helps them improve their maps overall. And we do know that this is pretty historic funding, $1.86 billion coming to the state to make these investments. So we have a great portal up and running for this. We have staff that is available to help at any time. If you have challenges, please don't hesitate to reach out. I'll put the information, I'll send it over to Amanda so that we can get it up on the screen at some point. So you'll know who to contact and how to get some additional resources for that work. Commissioner, is there anything else you would like me to add?
No, I just wanted to make sure that we announced that that process had opened so that we can maybe hopefully address some of the issues that we're seeing with the mapping.
Any other questions? If not, I think it's our lunch break. Thanks for your attention.
All right, everyone. So we'll have a lunch break until.
So ready? Okay. Just wanted to say welcome back for the afternoon session. Secretary Snyder Ashari will be joining us virtually for the afternoon. And with that, I'm going to turn it over to Amanda to introduce the moderator and next panel, and we'll get started for the afternoon discussion.
Thank you so much, Commissioner. Our final panel is the Energy Utilities and Telecommunications Provider panel. And we have the 3 large electric IOUs as well as AT&T here. And I will turn it over to our moderator for the session this afternoon, Tony Brunello.
All right, my job is to say as little as possible. So that is my role. So I'm Tony Brunello. I work with California Strategies. I used to work with the Natural Resources Agency long ago and do a lot of work in this building. I also work a lot with tribes in the north, so very honored to be here. I think just quick comments from this morning. I think this is an excellent dialogue. I know I have learned a ton, and a lot of this needs to be shared with many other people. So in the way I see this is sort of an evolution of really a conversation of understanding where the federal government is, the state government, great presentations by the tribes, just to understand what are the core elements. And now we'll be talking a little bit from the utility perspective, which I know has been discussed this morning. But I see this really as an evolution as we've looked over time. Our regulated utilities have also been here for a very long time. And like any group, like the regulations, I think Linnea was talking about, the past is not the future. And I think as we look to the future, I know personally a lot of the utilities are really trying to change as well. But I think this dialogue is a great, it's not a starter, but I think something that will obviously evolve into a lot more specificity, especially I know from a lot of the work that I do, and I think many of you also, there are exceptional demands on our energy infrastructure today and in the future, and with telecommunications. There are tons of permitting issues just to try and reach our clean energy goals. I see really an opportunity with tribes as excellent partners of being able to work on many of the issues that the state is trying to accomplish. And I think we heard some of those examples today. So even on the difficulties, there are also great opportunities. And I think I'd love to talk a little bit about that near the end of the presentation. So we're just going to have quick presentations, and then I hope some quick Q&A at the end as well with some of our utility representatives. So first we'll start with John Ritter with San Diego Gas and Electric. So John. And I think it's already up. Is that right? Okay.
It's up. Just use the clicker, John.
Sorry, John.
The big button.
Okay, thank you.
Okay.
Thank you very much. Good afternoon, everybody. Can you hear me okay? All right, good afternoon, everybody. There we go. Believe it or not, I volunteered to be the first utility to go this afternoon. So here I am. Normally, the after lunch time is a little bit slow and mundane, I know, but we're looking for a lot of excitement in these presentations today, right? All right, so definitely want to thank you for the opportunity to present today and to connect with so many fantastic customers of ours, stakeholders, and the public agency representatives. I would also like to acknowledge a couple of people from our company who are also here today. Cheryl Bowden-Reyna, who is our Principal Environmental Specialist for Cultural Resources. Cheryl. And then Lily Backer is also here. She's our Clean Energy Regulatory Strategy Manager. Lily, where are you at? Back over here. Great. Thanks for coming up today. Right one? All righty. Yes, today I'm going to briefly go over some introductory slides, our territory, the tribes we serve, our right-of-way process, and then I'm going to dig a little deeper into our experience with right-of-way on tribal lands and some of our right-of-way documentation. But more importantly, I think what you all are interested in more is what we are looking at in terms of improvements. So our service territory is primarily San Diego County and Southern Orange County. We strive to improve the lives and communities in our service territory by building the cleanest, safest, and most reliable energy infrastructure company in America. We definitely have 4,100 square miles of service territory, which I know to some of our partner IOUs out there doesn't seem like a lot, but to us, it's definitely a challenge. We have over 3.5 million consumers in our service territory and 4,600 dedicated employees providing our services. So a little bit about the tribes we serve. There are 17 federally recognized tribes in San Diego County. That's more than any other county in the country. All of them are in high fire threat districts, and most of them have typically been impacted by our public safety power shutoff programs. All of the tribes SDG&E has a privilege to serve are in the high fire threat districts, which means we've been working in earnest for years with the tribes to ensure its facilities are hardened, safe, and reliable. We also collaborate with the tribal communities to protect and preserve the cultural resources. And SDG&E will continue to work collaboratively with the tribes for all future work. So SDG&E right-of-way and facilities. I'm sure you're all disappointed, but I didn't include the definition of easements, right-of-ways, permits. But I just wanted to mention, of course, it's our obligation to acquire, protect, and dispose of land rights on behalf of our ratepayers. Of course, right-of-way is acquired to ensure our legal access to operate, maintain, and repair our overhead and underground facilities. We do have over 2,000 miles of electric transmission facilities, over 24,000 miles of electric distribution facilities, and 15,000 miles of gas facilities. On an average, our SDG&E Land Services team completes over 1,000 right-of-way acquisitions a year. We currently have an internal team of 5 FTEs, which includes 1 supervisor. And we have 4 third-party partners that provide right-of-way acquisition services for us. So this is our right-of-way process, and I'm not going to walk you through each step. You all have the slides. You're welcome to look through them. The process steps outlined above are for one of our typical right-of-way applications and are in alignment with the BIA requirements. There are differences depending on if it's one of our own internal projects or if it's a customer request for service. And so this is just a typical process and the typical steps completed by our right-of-way and survey group. Our environmental services team is also an integral part of the process, and their steps are outlined in the next page, but they do occur on a parallel path with ours. We partner with each other through the process. In addition, SDG&E has a variety of tools in place to ensure that throughout the process, we respect tribal sovereignty and solicit tribal input. These tools include a dedicated tribal relations team, which you heard one of our members name, Jennifer Summers, earlier today. It includes a lengthy access protocol with each tribe so we know each tribe's requirements when accessing a reservation, and a cultural resource team that works to minimize the impact to cultural resources and engagement from our senior leadership as well. The environmental right-of-way process is our environmental services group, and they conduct the tasks outlined in the slide to support the BIA NEPA process. These include early consultation with the tribes, regularly scheduled meetings with the BIA to discuss projects and obtain input to ensure the required documentation is developed. They conduct the cultural resource surveys, testing or monitoring, and closely coordinate with the Historic Preservation Office and cultural representatives. A little bit about our experience with right-of-way and tribal land. In 2023, we processed roughly 65 requests that were tribal related. And that number actually doubled from the year before. And this year, the trend seems to be going in the same direction. All the tribes we have the privilege to serve are of critical importance to us and at the top of our priority. And some of the comments you heard earlier today, which I'll comment on the last slide, are meaningful to us, and we do take them very seriously. Some of the projects we've been involved in over the last decade, which many of you have seen, are fire hardening projects. We've implemented the FIRM project, the PRIME project, a wood to steel project. We're currently doing covered conductor, and we have a strategic undergrounding program that's very aggressive in terms of miles of undergrounding, all for the sake of fire hardening. So right-of-way documentation tracking. This is one of the agenda items they asked us to address. So at SDG&E, we have an enterprise asset management system we call Archibus. It houses all of our documents, over 1 million scanned images of all the right-of-way documentation, permits, encroachment agreements, all reside as an image file in Archibus. We also use this tool to track each service request, not just from the tribes, but throughout the whole company. Customers who call in asking for information about their property, all the way to right-of-way acquisition and survey. One of the challenges we have is that, like many companies, we have different systems that are being used by different departments. So we use Archibus to track land management information, and our environmental group uses a system called Environmental Tracking System, and our design and project management group uses something different. And that is one of the areas of improvement that we are looking at targeting. Okay, so some of the areas of focus for us now and over the past several months and moving forward include an increase in communication, not only with the tribes through our tribal relations and tribal liaisons, but also with the BIA and with other agencies. We have shifted our engagement to an earlier place in the design for services when they're requested. So we're taking the first steps with right-of-way at 30% design rather than later at 60 or 70% design. We're doing more workforce planning, talent development, cross-training, and knowledge transfer. One of the things mentioned earlier today was about the lack of resources, and it's not just the BIA, it's not just SDG&E, it's all of the contractors, it's our design teams. It doesn't matter, it seems like at times, each group is at times experiencing either a high vacancy rate or a high turnover rate, or a combination of even both. And so at SDG&E's Land Services Group, we have recently added another right-of-way agent. The person I heard mentioned earlier that maybe went down on disability was with our Design and Project Management Group. And so it is important that we keep communicating so we get the information right and we know where the holdup is, maybe in a project, and we can focus our resources in that area and get the project moving forward. We also have a pretty sophisticated GIS system that we're enhancing with all the tribal right-of-way information that we've been able to obtain and verify. And then we're doing some things with Archibus to provide better reporting, follow-up when there's delays with our submittals. And then lastly, one of the things I'm really excited about is we're experimenting with AI and have actually finished a pilot where AI is doing some of the research activities for us. It's going out and grabbing documents that's taking less than half the time as somebody else on our research team. We're also looking at ways that AI can look at plat maps and compare the information on a map with the legal description to find the errors. Rather than what does seem to happen at times is you have, even with the federally certified surveyors that we brought on board, there's a human error element to it that takes a lot of time. Once it gets to the bill surveyor, they review it and they find an error, then it comes back to us. We're hoping that this AI tool at some point, someday, eliminate all the errors and reduce the back and forth on survey information. That's where we're going, that's what we hope to achieve, and be looking forward to taking questions at the end of the session. Thank you.
All right, Aaron, come on up. And you can see that we started late. You guys were a little sleepy, so we're just combining. We're going to go quicker. Hopefully have some Q&A at the end. Aaron? Okay, I think, yeah, already up.
Thank you, John. Thank you, John. Any relation to John Ritter, the actor? No? Okay, sorry. I had someone asked me that earlier. Asiam and Estella Chesiam, Hauhitan Sanetsnat, Chachwalamison, Heichka. What I said was my traditional name is Hauhitan. My English name is Aaron Thomas. I am from the Lummi Nation originally, up in Washington State. And I'm very blessed to be the tribal liaison for Southern California Edison, and working with 13 federally recognized tribes, an additional 18 non-federally recognized communities as well in our service area. And I want to thank the CPUC for inviting us to come and share with you and collaborate with you. It was great to hear the conversations with the tribes this morning. As a tribal member myself, I really feel like being able to engage with the tribes is something that when you come from a tribal reservation, you understand a lot more. So when I was interviewing for this position almost 5 years ago, I told them, I said, hey, I don't care who you end up getting as your tribal liaison, but make sure they're from a tribe. And that's number one, because you would say, well, but there's only few of us that really have the education, qualification, and experience to be able to step into a role like this. It is a role that I know PG&E Tribal Liaison Reno Franklin, SDG&E Tribal Liaison Jennifer Summers and Vanessa, we all take this very, very seriously, what we do. Vanessa comes from the Navajo tribe, Reno from his tribe up here in the northern area. And so we understand why energy is so important to our communities. We also understand sovereignty. Sovereignty is where it all begins. And for us at Southern California Edison, that's something that was brought up earlier this morning about what is it that that utility companies are doing. Well, some of us are educating our own. I'm thankful that I get to have share time with several hundred Edison employees each year to educate them on what I call Tribal Nation 101 presentation, because a lot of them have city and county experience, but they've never worked with the tribe before. And some of our policies were outdated, where we would just literally tell the tribe, we're going to be coming in with a drone on this date to inspect our lines, or we're going to go into your reservation to do veg management. And I was like, no way, man, that's not the way it would happen on my reservation. My tribal council would be down on that utility company saying, what's going on? Why are they just coming into our land? And so I had some internal conversations all the way up to the very top at Edison to be able to sort of make them aware that, and they finally decided on the fact that, well, we want to make sure we're doing what's right for the relationship with the tribes. They got it from the very top. So, if we want things to change and improve with our tribes and with the tribes in our utility companies, it's a matter of trying to make sure that internally that we're all engaged. Edison we do honor tribal sovereignty. And especially over the last 5 years, I said that, one of the things that when I first got this position, Amy Olson and we kind of tag team the tribes in making sure we get the jobs done. Things come into our email inbox, and one of us, we don't care who does it, we just get it done. And that's really what it takes, because it can pile up, as what was said this morning with some of the tribes saying, man, we've been asking this for decades, and how come it's not getting done? Well, it can happen, but you just got to get it done. We ensure that we have good faith negotiations and having a meaningful conversation with tribes and not just a one-way. It's not something that we as utility companies will tell you we've been good at over the last, Edison's been here for 138 years, and we were called something else before that, not Edison. We haven't been the greatest partner in the history of tribal utilities. But just like someone said earlier, just because of what happened in the past doesn't mean that it has to be this way in the future. So having these good faith negotiations were prevalent when Edison and the Morongo Band of Mission Indians, we entered into a long-term agreement, a long-term right-of-way agreement to form the West of Devers transmission project. Now, what an example of a major utility company and a tribal nation coming together, first of its kind in the history. So we've seen these great faith negotiation play out in other types of projects, nothing as big as the West of Devers, but when we're talking about the Tule River, or the Bishop Paiute, and Morongo, when creating electric vehicle charge stations, as small as that, that's huge in the development of making sure that we're taking care of 7 generations from now. It was talked about this morning about the temporary access permits. What an awesome negotiation agreement that we came through and said, hey, we have this opportunity to power all these homes that are coming all of a sudden. One day I want to go back to my reservation and put a house there. But what if I can't get Puget Sound Energy to help me power it? That would be horrible. And so, I'm thankful that we as a team, I set those meetings up with Morongo, and we sit down as much as we can. Sometimes it's every couple months, but we go through each and every one of those accounts and say, where are we at with that? Now, these are the ways that we overcome challenges, and it doesn't mean that we have to be at each other. And, like I said, we weren't perfect for 138 years, but now we've got a great team of people all the way up to the top with Steve Powell and Pedro Pizarro, who get it and they understand what it means to be great partners with the tribes. So again, we sit together. I put out an invitation to all 13 federally recognized tribes in our service area twice a year. Hey, it's time. We like to come see you in person, because as a tribal member, I know my elders always told me, never do things over the phone, son. Do things in person as much as you can. And of course, we had COVID, and that was horrible. We couldn't come see you, but that was another big part of it. Again, understanding tribes are not all the same. We all know that. But we all have some underlying sort of cultural norms that we have, and that was one of them. So again, we know like the West of Devers project was big, and we wish we could have done it and those kind of projects sooner. But as we said this morning, we heard about all the right-of-way issues that goes on. And I'm totally learned a lot today from listening to Yvonne and others talk about and the tribes talk about how we have to get better at, auditing our own service area to see where are the holes. What I've already talked to Roger, who I'm going to ask to come up next. Roger and his team, he'll talk to you in a minute here about our development, the way that we do our processes. But what is the way we can try to eliminate those holes to make it easier? Because I don't want to fire drill. where tribe is coming to us in the, sometimes in the last minute, right? They've got 1,000,001 things they're dealing with. But hey, Aaron, we've got, $10 million for the EV charge station. But we try to go out there and do it in the amount of time, and it's too late. As a tribal member, I don't want that to ever happen on my watch, especially. And so we wanted to get better and improve those little things that are big. And it's going to take us time to get those done, right? Working with Yvonne and working with others to try to figure out how can we, see those easements are fully vetted and they're identified, and we can try to work with the tribes much better. So just these few words before I'd like to invite Roger Zhang to come up. And he's going to share with you the PowerPoint deck here and be able to share with you what great ways we're trying to work with the tribes that way.
Oh, perfect. Thank you, everybody. My apologies. I'm getting over a cold, but not contagious. Don't worry. But just myself, I'm Roger Jung. I'm the new government lands manager. My team focuses on public lands and tribal lands only. I actually just moved over from working in our private lands side, so completely different. But I've been working with my team and who's been in their roles for many years, so they've been working really close with a lot of the tribes. But just a little quick overview of Southern California Edison. We power up to 15 million people in 50,000 square miles across central coastal Southern California, excluding cities of Los Angeles and other cities. Excuse me. Other service territories include more than 180 incorporated cities and 15 counties. I know we mentioned that we provide electricity to 13 tribes, but we actually have over 40 tribes within our service territory. Some of the programs that we have that we request through tribal lands is our huge project, covered conductor program, which is to install covered conductor in high fire risk areas in order to grid hardening of wildfire mitigation solutions to reduce the wildfire ignition risks associated with overhead electrical distribution systems. One of our other main projects we have going on is our targeted underground, which is called TUG, is a program to underground our overhead circuitry in high fire risk areas as well. We also have deteriorator pole replacement, our veg management practices from brush clearing, tree trimming, and removal. And again, all requests that we do all have to be approved, reviewed and approved by the tribes. In addition, we have drone inspections for aerial inspections. Some of the tribal requests we get we get a lot of the service line agreements, line extensions, EV charging stations, and then also tribal land to transfer policy property. For prior to any work that we do, it required any ground disturbance. SCE Environmental Services Department will conduct environmental and cultural and archaeology analysts on reservation allotted lands. Environmental and cultural analysts will be done in conformance to NEPA and other applicable federal regulations. On private lands, environmental and cultural analysts will be done in conformance to CEQA and or applicable state regulations. Mitigation requirements to protect species and historic sites, included those documented through consultations and recorded as part of the SE's project environmental requirements document that is given to a construction team prior to any ground disturbance of work. The need for any environmental and or cultural monitors to be present would also be indicated on that environmental requirement document. SE Government Lands will send an application request and to the associated tribes to request the approval of necessary work. Most operations and maintenance activities do not trigger NEPA or CEQA and are conducted in compliance with other federal, including the Section 106 of the National Historic Preservation Act and state regulations. And yeah, so in a nutshell, I am very new to this role. I've only been 3 months in, being part of this right now, this conference, learning so much, just in one day is tremendous. So I want to continue, partnering up, listening to, the tribes. My agents have worked, many, many years with, with a lot of the tribes. A lot of them, come from certain tribes as well. I'm really listening to, not only to my team, because they're very passionate about what they do, but also listening to, all the people that they work with and kind of seeing what are the issues, how can we work better with them, and they have so much good information. So I'm absorbing this all in and taking it all in, and hearing all this now, I want to make, improvements to the team to handle all these requests that we're getting, not only for the work that we requested, but also from the work, the things that you guys, that is being asked from us as well. We want to be better partners, and we want to be able to, communicate things sooner and work, as quickly as possible, but doing every step that's needed in order for us to, to get the work done. Thank you.
Thanks, Aaron and Roger. All right, Pratibha with PG&E. I think I still haven't figured out how this thing works. There you go. There you go. All right, Pratibha. Yeah.
Thank you. Thank you, Roger, and thank you, Aaron. So yeah, I'm here representing PG&E. Reno Franklin could not be here, who's our tribal liaison. And I'm a principal program manager, and I wrote this 5-minute meeting. That's how I'm here. Just last week, I was in India, and I came home to realize that, oh, I'm opted for this. Okay, I will show up. So last minute, I was like, I wrote this 5-minute meeting like in 23. It was updated in 2023, but I wrote it in 2021. So the whole idea, like, it was definitely such an eye-opening thing, and I'm so glad I did make in person, because I'm still jet lagged and I was trying to get out of in person, but I'm so glad I'm here today. Thanks to our commissioners also for setting this up. This is really a great platform for all the stakeholders to come together and talk about the problems that challenges we face. Like even our company, just like SCE and SDG&E, we want to do the right thing too. PG&E wants to do the right thing as well. I call my company an ocean because we are people of 23,000 employees, and with the the service territory is pretty huge. So, and then with that comes different departments. And it's sometimes like I've been around for 17 plus years. And for me also to figure out like, okay, who do I contact for this? How do I resolve this? It has taken me a lot of time. So you can imagine. So the need for this 5-minute meeting came about because just like we heard from Michelle Lee and even Leanna, that what they come across is that we have gaps. Like if there's a service line agreement, going back to tap off from the point where we have good right of way to tap off, there could be gaps. And if we don't close those gaps, we can't install in good faith a facility which is in trespass, because once we install, we are obligated to serve. So I am getting old. I thought I could read this, but so as you can see, like why the need for easement process, thankfully we have good people. Like my dad always said, like we have good people, bad people everywhere, every country, every company. So we have really good people too. We have a system called CAP, which is if you identify, that's corrective action plan. If you identify a loophole or a gap or a process improvement area, then you can bring it up. So one of the land tech had submitted that, you know what, we don't have any guidance like when we are working on tribal lands. They're very well versed with working with agencies, cities, counties, private landowners and all that. So that's when this came about. And at that time, I was an 851 senior land agent. So I looked into this and I closed the cap and I wrote this down. What was happening when we realized that we have a lot of facilities that were installed almost 100 years ago with no valid land rights, that's a problem, right? So this is in guidance to let them know. Oopsie. Oh, okay, big button. Okay. And if I go one more time, okay. So I know I don't have to go back into, I just want to go back one more time. Yeah, so how tribes hold interest in their land. I know I don't need to provide that education to anybody in this room here today. But this was necessary for our teams because we have estimators and service reps that prepare the easement documents, or we prepare the easement documents, sorry, they design how the service is going to go about. And many times they are not land experts like us. They are the front line. They are just designing how the service is going to go, and they're estimating, right? So they were not aware that if it is a tribal land, then they need to engage land right away. So this 5-minute meeting was rolled out to the service representative and estimating group. So as you can see, the very next topic is service planning and design, and their role into this is so we have a GIS system that we use to determine like what is the land ownership just from the get-go. So they can turn a layer on that has a tribal land ownership details. So then once they determine that, okay, in this land, we are going to be crossing whether to serve the tribal lands or we are crossing the tribal lands, they will immediately engage land department so that it doesn't slip through the land department's radar. And then we lay out in the next topic process to obtain easements on tribal lands. So we in land department, we prepare the easement document or right-of-way document, but we don't reach out to the tribal contact. That is usually done by our tribal liaison, which is Reno Franklin. So the very first thing is the ownership portion is trying to figure out, and I was talking to Yvonne a little bit ago, to ensure that our title documents, because just like SDG&E and SE, we have our own system of record, which has documents housed from microfiche to now, and there are like millions of documents housed there, and how we can ensure that those documents are available when title ownership is looked at and all that. So that's the portion that we look at. And then the whole process of routing the documents for signature, and then our liaison pretty much takes it to completion. We provide him with a cover letter, what we are actually doing. And then after that, our liaison, which is Reno Franklin, he takes it all the way to execution. And in between, if we need to engage any tribal leaders or BIA, if they are the trustee for tribal land, then they engage them. So that was my spiel for today. Not bad for few hours of preparation, I believe. So question answers after.
I have a question.
Yes.
What is a 5-minute meeting?
Oh yeah, thank you. It is a 5-minute meeting is usually like, it's not a procedure because procedure generally walks you through. It is a PG&E thing, yeah. Yeah.
Okay.
So it's not a procedure because it doesn't go step by step, but it creates enough awareness, so yeah. Okay, thank you.
All right, and for our last one, Julio with AT&T. So we've moved through the utilities. We are not talking about publicly owned utilities, and I'm sure there are many other questions here. Obviously, I'm looking to Commissioner Gallardo, but for AT&T. There, a big one.
All right. All right, last but not least, good afternoon, everybody. My name is Julio Figueroa, and I serve as the tribal liaison for AT&T California. I've been with AT&T for 25 years. Who remembers Pacific Bell? Raise your hand. That's when I started. So if you didn't raise your hand, you probably weren't alive when Pacific Bell was around. So we've come a long way from just delivering plain old telephone service to now delivering cell phone and fiber services. So today I was asked to come talk about some of the successes we've had with some of the tribes down in Southern California regarding fiber deployment. But before I do that, I do want to acknowledge my team that's here today, my colleagues from regulatory, Ancor, if you want to raise your hand, Renee and Josh. And I also have Safar here from our network department. He's here as well to answer any technical questions that I might not be able to answer. AT&T serves about 48 tribes out of the 109 federally recognized tribes in California. What does that mean? That means that we probably have infrastructure on their tribal lands, providing some type of communication. But for cellular service, there are no boundaries. We are able to serve all 109 federally recognized tribes should they want to collaborate with AT&T. For those of you that don't know, we're also the exclusive provider of the only mobile broadband network that's overseen by the federal government, which is FirstNet. So tribes that want to collaborate with AT&T to bring FirstNet, the public safety network, onto their tribal land, they would come to me. So what is my role is to be the single point of contact for all the tribes in California. It can be as issues as small as a billing issue from a tribal member, or as large as wanting to deploy infrastructure on their tribal land. If you ask the tribal nations that I collaborate with, they typically get a response with me within 24 hours or less. I don't make my tribes wait. Part of my role also, and I think very similar to other liaisons, is we are advocates for tribal nations with our companies. Some of our folks have been doing the same work and think that going onto a tribal land is the same as doing work on county and cities, and it's not. And so being the liaison, we get to learn kind of the rules of engagement and how to play on tribal land, and we have to educate our internal folks and prioritize to make sure that we get the work done and we do it right. So use us as liaisons. That's what we're here for, and we are also advocating for you as tribal nations to our companies that we represent. So my role in consultation is it's really rooted in respect and transparency and educating my internal folks on tribal sovereignty. Again, we can't do business like we used to do it, and we can't do that on tribal land like we're used to doing it on county and city land. So consultation, I think Aaron talked about it. It's very, I think for me, it's been critical. I've been doing the tribal liaison piece for about 3 years now of the 25 years that I've been with AT&T, and it has been imperative to cultivate and create relationships from the beginning. You know that Native American people, trust is very, very important. And if they don't know you, whether you work for a company or not, they will not open the door to come have you talk to them. They won't answer an email, and possibly won't even pick up your phone call if you don't have a relationship set up with that tribal nation. And that could be with the chairperson, with the IT director, with the tribal minister, anybody. But as long as somebody can vouch for you, then those doors will start opening up. I was blessed to have Chairman Mazzetti from the Rincon tribe take me in pretty early on when I was announced as the liaison for AT&T, and he took me up and down the state, meeting all the tribal leaders of California to say, hey, this guy's from AT&T. If you need anything, please feel free to reach out to him. He got me in front of the Southern California Tribal Chairmen's Association, Central California, Northern California. So from the get-go, I had an opportunity to meet folks at the very beginning that made my job easy. And after that, it was really tribes wanting to set up a meeting to discuss the solutions that they were looking for. And again, depending on which tribe was reaching out to me, it was like, okay, you're in our service area. We can discuss copper and fiber and everything else. But if you're out of our service area, the only discussion would be a cellular solution. And then I would also provide some type of consultation to say, hey, if you're going to talk to one of the other carriers that's outside of our service area, then these are the questions you probably want to pose to them if this is the solution you're looking for. So when we do a consultation, for example, for Rincon and San Pasqual, and we do have non-disclosure agreements with both of those tribes, but both Chairman Cope and Chairman Mazzetti allowed me to discuss both of those projects. And that is a fiber deployment to all locations on Rincon and San Pasqual tribal land. And that is fiber all the way to the customer's home. And so what did that process look like? Again, it started with a consultation meeting, understand what the solution they were looking for, provide a non-binding estimate, provide a proposal, and then let the tribe go out and seek other proposals. And then should we win a contract, then we would move forward to the next step. And we have moved forward with the Rincon tribe and the San Pasqual tribe. We are currently building on San Pasqual, at least outside the tribal land, to get it ready so that once we have BIA approval to put shovel in the ground, we'll start deploying on the tribal line. For Rincon, I think we're on pause right now because of the SDG&E project, underground project. We had to postpone or slow down our NEPA survey because we're going to discuss possibly working together to discuss SDG's underground plans. But that's just an example of collaboration even with other entities within the service area. We have non-disclosure agreements probably with 10 other tribes up and down the state. I can't disclose their names because I have not been given permission, but we are just waiting on funding from the sources that they've reached out for regarding their grants, NTIA, FFA, CASF. So as soon as those funds are secured, then we will move forward. We'll probably start announcing additional collaboration with other tribes up and down the state. I know that there was a question if we're working with tribes in Northern California. We are. It's just we're just waiting on funding, and the NDAs prevent me from disclosing which tribes there are, at least at this moment. Typically, San Pasqual and Rincon are probably one of the larger tribes for us in California in our service area. So we can get a design engineering done in about 120 days or less. And during that process, we are meeting with the tribe on a regular basis to ensure that we are identifying every location that they want served. For those of you that are part of the design engineering project, once it's done, it's expensive to go back and have to redesign because we missed a couple of locations. So we ensure that we are meeting regularly with the tribes to ensure that all the locations are identified. And then during that process, once that agreement is signed, then we start working with the BIA. We co-work with the tribe and BIA to ensure that we are submitting all the requirements to get that right of way and that easement. Right now, I think NEPA is taking us about 8 months, at least projected to get done. And then our survey, we have to do an entire new survey to get the legal plats, the legal descriptions and plat maps done. So that's taking a little longer than what we anticipated. But I think working with the BIA, and I think Yvonne could share with you that, you know, our right-of-way folks are constantly in communication with Yvonne to ensure that there's nothing pending from our end to make sure that that application goes through. So how do we track our right-of-ways and easements? We have a right-of-way team that does that up and down the state. And we work with the BIA, making sure that all the documents and the application has been submitted with no documents that are missing. And again, we meet with the tribes on a regular basis to give them an update on how it's going. San Pasqual even asked me to come out and to speak to their membership at one of their membership meetings to discuss the status of the fiber deployment, because it's that important to their membership to get broadband connectivity to their tribal nation. So the chairman said, hey, can you speak to our membership? I'm like, I'd be more than happy to do so. And that's what we do. Areas that I think could help in the expedite process, I've listed in my presentation. And another item I think we could look at is, you know, I encourage the CPUC to look at some of the funding that is pending still, CASF, FFA, and even upcoming BEAD to prioritize some of those applications to get funded and awarded as soon as possible. I don't know the rules on BEAD yet, and I don't know if it's going to be the carrier submitting the application or if it's going to be the tribe. I would encourage to make it as easy as possible. A lot of the tribes don't have the resources to even fill out those applications. So if they work with an ISP or a company that's going to provide the services on there, and that company can complete that application on behalf of the tribe and work with the tribe because they have the resources, that I would encourage to allow the tribe to work with that ISP or the company they're working with to complete that application for them. Other than that, that's my presentation, and thank you. Thank you for your time.
All right. The only reason I'm here is to keep you awake. So if you have no questions, this is going to be very quick, I think. So now we're going to start for a Q&A session. It would be much better if we were all in a nice circle to talk to each other. So I know this was not the choice of the commissioners and the other folks here. So we're going to do our best, because I think we're going to try and have both a Q&A to both the speakers from all three sessions this morning, federal and state, tribes, and from the utilities. So I'm also known for calling people out, so I even know you a little bit. I might ask people for some question and answers. So you know, first that. Second, I was going to look to Ken and maybe Amanda, where we'll do sort of an Oprah Winfrey style for a microphone, so we can come to you, or you can come up if you need to. But with that, why don't we first give the floor to the faraway dais here, which is so far away from us, but with the commissioners and Mark for first questions. So Darcy or Naomi.
I just want to thank the panelists for presenting today. Thank the utilities for being here and engaging in the discussion. I want to thank the earlier panel with the tribal representatives and all of the time and effort, and everyone I think had to travel to be here, and Michelle Lee for moderating that panel. I think this is the first of what's hopefully going to be more productive discussions on how to address these issues. I think we're all trying to look for solutions, and the first step to that is, I think, getting everyone in the same room. So just really want to recognize the time and effort that's gone into this, because we are all very busy, and I know folks have a million things that they're doing, and it taking a whole day out to be here and the time to prepare to be here and travel is a lot. So I just really appreciate that, and it helps me as a commissioner to understand what things we should be raising in our proceedings, and again, to further these conversations and discussions that we'll be having with our sister agencies. So again, I just wanted to thank everyone. I may have some questions later, but I do want to make sure that the tribal representatives in the room are also able to get adequate time to ask questions, but just wanted to see if Commissioner Gayak or Mark. Okay, we can go to questions.
Oh, who would like to ask the first question? So I don't see a hand, and I've got one. Linnea, perfect. I was going to call on you anyway, so that's perfect. That's good. I got a follow-up for you too.
So thank you to the utility panelists. I'm going to direct it to PG&E because that's who our IOU is, and I'm sorry to put you on the spot. So what tribes are doing throughout the state and throughout the country is we're developing broadband, we're doing critical functions, we're looking at nested microgrids. All that is going to require interconnection applications to be processed through the IOU, and we have to meet timelines. How do you foresee that from a PG&E perspective on how to fast track that and facilitate that in a timely manner? Thank you.
Lene, that is such a great question. I missed talking about it during my presentation. But like I said, we in PG&E love our CEO, Patty Poppy. She brought in such a great shift to our culture. So she's introduced something new called COTD, which is Customer On-Time Delivery. Because we were looking at it previously a different way, that we would see like how efficiently, like our parameters were so different, our metrics were different. Now we are focusing on how can we reduce that time to ensure that customers have service delivered on time. I am going to definitely connect with Reno Franklin more about this, and I'll definitely get back to you with more details on that. That's a promise.
We don't have to just have the fund for PG&E. If one of the other utilities or the PUC or CEC folks want to speak to that, because that is a very hot topic for how to expedite permitting, either for electricity or telecom. Julio.
I can't speak for the other broadband providers, but we want to build it just as fast as the tribal nation wants to build it. So whatever processes can be expedited, we're all for it. Like I said, San Pasqual, we're literally just waiting on the application from BIA, and it is, like Yvonne said, it's not a small package, and they have to review it, and it has to go through other departments to have them check off. So we're ready to build, and anything I think in the process that can expedite that, we're all for it. I think from Morongo, she mentioned earlier that they were able to set something up for housing where, hey, let's get the housing out here as soon as possible, and let's work on the right of way as we're building these houses. Why can't we not do that with broadband? Let's deliver broadband. Let's deliver fiber to all these tribal nations, and let's concurrently work on that right of way application as well to get tribal members served. It's a fiber line. So those are just my thoughts.
All right. Other questions or responses to any of the different proceedings? I can see you guys want to go home quick. Linnea's ready. You guys better step up. There's got to be somebody else. Linnea, we're going to give the next 45 minutes because she had a lot of things in that presentation, if you saw.
So this is kind of to all of the providers. I think all the tribes, and only 3 or 4 presented, but this is a countrywide problem where there's existing utilities on tribal land without appropriate documentation, right-of-way easements, compensation. So are there any plans to rectify and clear up title issues that exist in every tribal nation throughout this country?
Who should I go to?
You want to speak to any of that?
Vaughn, I'm coming for you.
But it's nationwide too, right? All right, I won't call out names then. I'll get in trouble here, I can see. No.
Okay.
All right. Darcy?
Just a comment on that question. You know, I think Morongo's presentation about what they've done by creating sort of an internal realty company, it sounds like has helped expedite things there, but I don't think all tribes have the resources to be able to do that. I don't know if there's a way, and that's probably a further discussion that all of us need to have, to work with the BIA to see what opportunities there may be to fast track how we process applications and what it means to get the right-of-way approvals in parallel with the energization applications and see how we can address things more efficiently. And I think the government agencies need to play a role in that and seeing where we can help make those things happen. The investor-owned utilities need to come to the table to sit down and work with us to see how we're going to be able to manage that within their systems. And then most importantly, I think we need to know what's going to work best for the tribes and how to make sure that they're getting these projects energized or interconnected on a timely basis, because it has real life impacts and downstream effects for the tribe's ability to govern, to have economic development, and just public health and safety, as we saw from the projects that are on the reservation that need to be connected.
Okay, well, we might wind down. Others, are there other questions in the group? Wow, you guys are quiet. This is easy. Linnea, I'm going to go to you then. Let's go, Linnea, one more. Linnea, you had a great chart, which in my mind, this has been a wonderful opportunity for me, and I appreciate the commissioners to at least educate us all on these topics. I had no idea of the database at the federal level that really is required for many of the utilities and services that we may or may not have right-of-ways. I think there's a massive opportunity where you talked about artificial intelligence or other things to gather information. That seems like step one moving forward in terms of a way that everybody could work together. Also the aspect of bringing tribes in earlier. I knew through my experience, just that's a central, simple ask, just bringing them in as early as possible to have that conversation, because especially, I think as Linnea is reminding us, tribes can help, and actually it's an opportunity to work with tribes. So getting them in earlier may help improve projects. So with that, I had my specific ask is you had a great circle that you framed in a very diplomatic way of opportunities. But what would you, if you're looking as the next step, what is our next conference for really trying to help narrow down an issue where we can bring this group back together and maybe start working towards implementation of how to improve engagement and making more of these projects work better?
Yeah, absolutely. Thank you for bringing that up. So we've heard a lot of presentations that gave some great detail, right? You're looking at Code of Federal Regulations. You're looking at the processes that are set up. The next step would be to have a workshop to sit down and talk about real world implications. How does that impact this project? What is the next step? Identifying, the next process and the people to conversate with, because you can read and hear panels on statistics, but until you sit down and talk about them and how that affects real life projects and timelines, that's where you get into the meat of the project and solutions.
Okay. I'm going to hand it back to Commissioner Houck.
So I do have a question then, I guess, if nobody else in the room has a question. There's a question right there. So go there, but I will have a question after that.
Yeah, so this is John Ritter from San Diego Gas and Electric. I was just hoping to get clarification, maybe not today, but in the future, on what I heard from, I think it was Morongo, about the temporary use permit for running the services. and getting the housing electrified sooner. Our guidance from the BIA in the past has been that we are not allowed to use the temporary use permit for construction of electric facilities, that we need to have a right-of-way, that the electric facilities are not a temporary use. And so that may be a solution for the Morongo tribe, but it's not been a solution for us, but maybe that's something that could be clarified or changed or not. But just so there's no misunderstanding about why the IOUs aren't doing it when maybe one of the tribes is, we should probably get to better understand all that. And then secondarily, I just want to make a comment about the resolving all of the facilities without right-of-ways or easements. And we have an experience with that on at least a few tribes in San Diego County. I won't mention the specific ones, but one of them, for example, was because of an acquisition of an electric system that happened 50 years ago. And we acquired a lot of distribution facilities with no land rights. And, you don't really even realize it until you get to somebody needing a service line agreement done. And then all of a sudden, well, wait a second, here we have a line of poles that somebody either initially put there because they thought it was a service line extension, or we just don't have the rights. And so what we're doing is every time we're getting requests, we have to, of course, go out and acquire the right-of-way, and we're doing that. But we're also programmatically, very slowly looking at one tribe and then the next to try and resolve all the open facilities without rights-of-way. So it's way too much to handle collectively for all of it at the same time. We barely, as you heard, have the resources at times to get through the workload we have, let alone take on some extra. But we're taking it a little bit at a time and hoping to make some progress that way. So those are my 2 points. Thank you.
Get it. Did anyone respond? Or on that one specific one, was there anything?
I would just say that we don't know what we don't know, right? So the tribe should also reach out to us and say, hey, listen, we don't believe you have a right of way here. A lot of our facilities have been there for 50, maybe more than 50 years. So a lot of what I'm seeing is triggered by the tribes reaching out to me saying, hey, Julio, your lease is up for this cell site, but we also noticed that the right of way, you don't have one there. And this has been sitting there for 20, 30 years. So yeah, let's clean up what we currently have now, but we don't know what we don't know unless the tribes let us know that, hey, you don't have a right of way here. And again, that infrastructure might have been there for over 50 years. So let us know and we will work on making sure that we're up to date on right of ways.
Good.
Yeah, thank you. Jack Mulligan from the PUC. I wanted to thank all the presenters first. I'm learning a lot here today. I've worked on permitting issues for a long time, but not acquisition. So I had a question about money and obtaining right of way. What role does coming to an agreement on acquisition, on the value of property, on the need for rights of way on tribal lands, how much of that is a time component versus just getting the deeds, the right of way, the everything recorded the right way, the title? Is there a lot of, because I don't understand if like the utility comes into tribal lands, if there's expectations or bargaining or if the acquisition side is a big component of this, or if it's just a really small thing, like once the right of way is set, it's pretty easy to determine the cash.
Any answers? I mean, Linnea, this is going to be your panel. This is the Linnea panel.
This is just from my perspective, right? So yes, the valuation is one component of the whole, right? But you're looking at infrastructure that is A, going to take space, B, be there perpetually. And then these companies, sorry to say that like that, but come in and kind of just do management and other activities without any further conversations with the tribe. So there are considerations where they can waive valuation, but there needs to be a give and take of assets. Is it control of services? Is it, providing other kind of non-monetary solutions back to the tribe? Because it is a taking. There's a right of way, there's a certain footage on each side where that land is then not usable for that. So it's something that definitely needs to be compensated in some way.
Great, thank you. Well, with that, why don't we hand to Darcy for her question, or Commissioner Gallardo? Or comments, final comments.
So I had a question about Yvonne, you may be able to answer this, or any of the utilities, or if the tribes have had experience, but slide 27, it talks about needing a new right-of-way under certain conditions, and one of those if it's going to require ground disturbance. And I know when Michael presented that one of the exemptions for our GO 131D was listed as conversion of overhead to underground. So if there is an existing right-of-way for overhead, but the utility wants to underground, it sounds like they would need to get a new right-of-way. And I just wanted to get clarification if that's accurate, or how the utilities or the BIA or the tribes address where there's going to be ground disturbance for existing infrastructure on tribal land.
So typically, if there are any ground disturbance, it sounds like it would be not a new use. It sounds like it would be the same use within the same scope. You're just going from overhead to underground. I can't give you a definite answer. I don't want to steer anybody in the wrong way by giving an answer to that, because there is ground disturbance. I don't want to say you would have to get a new right-of-way. I guess it depends if you're going to be within the same right-of-way footprint, because you're not, it doesn't sound, if you're in the same right-of-way footprint, you're not increasing acreage, you're just going from overhead to underground. So typically the key word there is ground disturbance. But again, I'm not going to steer anybody in the wrong direction. So I would have to get guidance on that before I give a definite answer on that one.
Okay, and I guess one of the reasons I'm asking is we've heard in our consultations with tribes concerns about when there is ground disturbance, even within an existing right-of-way, that has impacts or could have impacts, particularly to cultural resources. And in some cases, it seems like if it is the same use, if it's going from overhead to underground, there's an assumption that the easement holder there's a disagreement between the tribe and what needs to be complied with for purposes of tribal law versus what the easement holder believes their rights are. And so that was something that was highlighted to us as we were meeting with different tribes. And so I just didn't know what folks' experience was on the ground in looking at what kind of consultation or engagement there was with tribes where there would be ground disturbance for existing infrastructure that was being moved from above ground to underground.
Just to make a comment on that, any federal action triggers NEPA review. And our subject matter experts are the DCRMs for BIA purposes. So even if it was an amendment to a right-of-way, that's a federal action that triggers NEPA. A right-of-way is a federal action that triggers NEPA. So anything that is signed off by the superintendent at the BIA will trigger NEPA compliance.
Thank you. And yes, it'd be great to hear from IOUs.
Yeah, even before Roger became in the position he's with government lands, I've been asked that several questions before, and we always go on the side of being careful. If we're going to be digging anything, we want to make sure we have a monitor and make sure that we're communicating with the tribe that it's affecting, so that in case we do run into something that we're not held liable for it as well. So that's again, it's a questionable thing, but it's also, we lean on the side of trying to continue to strengthen the relationship with the tribe, because all it takes is somebody driving by and seeing us digging, and then they're questioning it and calling tribal chairperson X, and they're calling me saying WTF. So we're not going to just dig. We're going to make sure that when we're out there that we're going to be following, and that's more cultural protocol. That's the way I see it. It's tribal traditional law that you just don't dig where it's possible you run into some cultural resources. So.
No, thank you. And I think Karen also had a comment.
I understand we're talking about existing easements that are overhead and going underground. It also depends on what's in that easement deed, that right-of-way deed. If it states in there that's for the purposes of an overhead infrastructure, then that's going to change the purpose of going underground. Now, I don't know, I would think for the Bureau, it's going to be requiring a new right-of-way because now you're changing the purpose. That would affect it.
And for the two projects we're doing down in San Diego, our proposals were like for like. So wherever our current copper network is at, we're going to follow the same path to minimize land disturbance. But in those discussions and collaboration, you know, the tribes will let us know, hey, listen, can you go underground in this portion of your deployment because either these poles get hit a lot or there's constant fires that are happening in that area. Because they know that territory a lot better than we do, then, you know, we'll take that into consideration as we're designing and engineering. So.
No, thank you. Another question, I think I asked it earlier to the tribal panel, was just some of the timing on the energization. That's obviously something the commission's looking at very closely now as we're looking at a clean energy transition. And I understand that if you need a right-of-way or something wasn't tracked correctly, like what we heard today, getting a service line agreement may not be as easy or simple as it would be otherwise. How are the utilities balancing that obligation to serve with the timing on getting locations on tribal land energized? And I know that, or what things do you want the commission to know as we're going through like our high DER proceeding and our energization proceeding and trying to come up with ways to be more efficient and expedite the energization process? Are there specific things that you think would be helpful for us to know or to think about as we're developing those rules that are specific to your engagements on tribal land or certain barriers that you're seeing and being able to expedite those energizations for tribes?
You know, I know that we will never want any outside of the tribe to tell the tribe what to do. That's something we would never want as a utility. Tribes are their own sovereign nation. They can do whatever they want. They're the supreme authority. However, it would be nice for us to, well, first of all, to listen to each tribe because each one of them are different, to understand what their needs are in this space. And secondly, if there was a mutual agreement where we could ask for any kind of streamlined permitting, that would be very helpful. But again, streamlined permitting, it's not like they're all cities where we can ask all the cities to do that. Tribes are different and they're one at a time. And so being able to ask the PUC to talk to the tribes about the space would be very, very helpful because sometimes when we ask, it isn't clear or they don't really know what they want in that space. But if they had another group to ask, maybe that's where we can get some information too. So helping to bridge that communication gap would be very helpful.
Any response? No.
And I guess just a last question there. I think we've been talking about community engagement in regards to climate adaptation, in regards to high DER and energization, and as well as in wildfire mitigation and safety issues. Do you feel that having that community engagement with the local governments and the tribes specifically is going to help provide more information upfront to incorporate into your planning processes?
Yeah, so that's why we set up the Tribal Leaders Clean Energy Summit every year. Last year was our last one of the Clean Energy Summit because a lot of the tribes told us what we were sharing with them, bringing them to the table, asking them to come to the table, them hearing the invitation to come to the table, let me correct myself, is the fact that we were saying things that were way over their head. So this year, we have partnered with the Pechanga tribe. We definitely thank our Pechanga partnership that we have. We're having the Tribal Leaders Energy Summit this year, which is basically a kind of an energy 101 because as a lot of us know, energy's got its own language, its own jargon, its own strategy. So bringing and inviting the 109 tribes to the table is something that the PG&E, SDG&E, and Edison, as well as CalSTART, have agreed that that's a great way to meet them where they are, to help collaborate and share in that day and a half with them how we can better collaborate, how we can better partner. We're trying to make it a real fun day and a half. But in the meantime, doing business and being able to have those hard conversations in person. When things aren't working, we have that time with them. And so I think that engagement is humongous in having that in-person, day and a half, sponsored by the utility companies and Pechanga, as well as a couple other sponsors, making sure that we get them to all of us to kind of better collaborate in the energy space.
Thank you. And I want to see Commissioner Gallardo, did you have any questions?
Just a general question. I think this is more so for the representatives from the tribes. I'm just and I'll be frank here first to explain. I'm mostly here in listening mode. A lot of this isn't necessarily in the jurisdiction of the Energy Commission. However, we work really closely with the Public Utilities Commission and our other peers, and we want to make sure that we're learning, where we can be more productive, constructive, efficient, effective. And so that's why I am here, and my team is also here. We have several folks from the Energy Commission. They're sitting over there in the corner, so I want them to raise their hand. But we have here our Director of Tribal Affairs, Sierra Graves, who's also Tribal Liaison, my Advisor and Acting Chief of Staff, Jimmy Kakunda, also my new fellow, Audrey, who's out there as well from Stanford University, and also Sean Anaya, who's a Tribal Liaison, Assistant Tribal Liaison at Energy Commission and from the Research and Development Division. So, we're all here listening, learning, et cetera. So now to my question, I was just curious, in all that I've been observing and listening here, there are some concepts that, we can all apply. For example, meeting deadlines. Seems simple, but that's a big one. Also, just being really meaningful and thoughtful in terms of our engagement and relationship building, et cetera, being better partners to each other. And it seems like this venue was really valuable in being able to talk about all these processes, all the various steps that everyone takes, all the legal stuff, that happens. I got a little bit traumatized, and it sounded like, law school for me at the beginning. But there's all these, things that we have to know that can be complicated, not necessarily always over people's heads, right? We're all trying to be really thoughtful about learning all this. So anyways, it just makes me curious for the tribes. Do these types of venues help? Do we need to have more of these? Do we need to have regular meetings like this? Or is this, one way of doing bringing some value? And is there anything else that we can do as state entities and with all the partners that we have here in the room?
I definitely agree that it's important to have all the stakeholders, the utility investors, the tribes, all in one room to talk about the issues. It's not possible to do 100 tribes and get everybody in the group, but maybe perhaps thinking of Southern California, Central, and then maybe Northern California, rather than just everybody trying to meet in Sacramento.
We're even doing a couple in Southern California.
Mm-hmm.
You can get one in San Diego, but then the tribes in Coachella Valley can't make this 2-hour drive.
Yeah, Commissioner, I'd just like to echo what Karen said, because I think with the different IOUs and the different regions, there's obviously different environments that we're dealing with, different energy projects. I think the regional projects is what has the most impact, because you have centralized and focused groups that are kind of dealing with the same issues with the same providers. And I think that probably has, and this, maybe once a year would be great, but a regional approach, I think, would be the most bang for your buck to get down to the real issues in that specific area.
Thank you. Would you like to say anything? Okay. Oh, and say your name and your organization.
Okay.
Good afternoon. I'm Pete Pitt, the General Manager of Pechanga Western Electric. We're a tribal utility serving commercial, residential, and governmental load in near Temecula, California. Thanks, everybody. I think, honestly, I've learned a lot here coming in and looking at the different roles and responsibilities that folks have. It's good to see some familiar faces. Looking forward to seeing folks in the future as well. But I do think this is very valuable to have the investment of time and have the different stakeholders in one place. It's definitely been helpful for myself. And I agree with an idea of regional makes sense, but I also do appreciate having the ability to come to the Capitol and learn what is being seen from different lenses, as I'm in one lens in one place, and it's very interesting and helpful to see what other tribes and other utilities and other entities are facing. So I think these types of time investments are a positive, and I look forward to the next steps in terms of when we can meet again, and we'll provide some written, I think, comments as well as we sort of digest this internally and run it through our departments because right now I already feel like there's a couple departments I wish I would have brought with me. So I think that now we're starting to see more of the value, and we'll take some time to put some words down and get them to you all, but appreciate everything. I think this has been an awesome opportunity to learn. So thank you.
And then along those lines that Peter Pitt just mentioned is, is there anyone missing? Are there any other types of entities that should be here? That would also be helpful to know, whether it's state folks or other utility representatives or anything else. You don't have to answer now, but there is that opportunity for written comments, so just putting it out there.
And I do think we have some other utilities that didn't present that are here in the audience today. And I don't know if they just wanted to identify themselves to know that they're at least part of the conversation. Yeah. That was Jenny Smith at Frontier Communications. No, it's okay. I know we've got a lot of people online, so I just wanted to make sure that anyone else that wants to. Okay.
I don't think the CPUC will have an issue getting the utility players to a meeting because we have the resources, we have the folks that they can travel, but I think leveraging when tribal leaders are meeting and maybe working off of that date so they don't have to travel again. So if the tribal nations are meeting at a specific place, maybe add a day before it, a day after that they're meeting so that you already have them there and the utility people will come out. It's just trying to get the tribal folks to travel. It's difficult because they're trying to run their business on their tribal land. So just a thought.
Thank you. Thank you. Appreciate all of the comments. This is very helpful, and I know we'll definitely be following up with additional opportunities for comments and workshops. I don't know, Mark, did you have any questions?
No, I'm not. Thanks.
You're sure? Okay. Okay, we've got another question. Online? Okay. Really quick, before we go to the online question, I just wanted to recognize that we do have Director Thomas Jacobs from the Office of Energy Infrastructure Safety here, and I just wanted to give her a second because the work that they're doing at Energy Safety is also very related to the work we're doing here with, so I'll turn it over to her in just a minute, and then we'll take the questions online.
Thank you, Commissioner Hauk. I really appreciate the chance to get to be here today and to listen to all of you. And thank you to the Commission and Bureau of Indian Affairs for organizing it, and to the panelists from all the different tribes and utilities. Learned a lot today. Did just want to take a moment to introduce our department because we are a relatively new state department. So the California Office of Energy Infrastructure Safety. It is a little bit of a mouthful. So energy safety. What we are responsible for is we have two regulatory missions. One is to oversee electrical corporations' wildfire mitigation efforts. So you probably are all familiar with the wildfire mitigation plans. It's our department that reviews and approves or denies those plans. We are currently working right now on setting the guidelines, the requirements for the next set of 3-year plans this summer. Those draft guidelines will be coming out. So just wanted to put that on folks' radar. Definitely welcome public comment and tribal consultation on those guidelines. guidelines. We are also responsible for reviewing if a large utility, large electrical corporation wants to submit a 10-year undergrounding plan. It's our department that initially reviews that plan. So for all of you that are thinking about infrastructure and undergrounding infrastructure happening on your tribal lands, just wanted to make sure you guys were aware of our department. We are also developing the regulatory guidelines for those plans right now. Those draft guidelines will also be going out later this summer, late July, early November. So again, really welcome public comment and tribal consultation on those guidelines. We also have responsibility as a department for excavation safety in the state. So the call before you dig program, if you will. So if there are excavation damage incidents on tribal lands, it's our department that is responsible for investigating at your invitation. So again, just wanted to make you aware of our department since we are a relatively new department. We've only been around for 3 years. If we can, I don't know if you'll be sending out information to this group, but for those of you that are in the room, I'll be sticking around, happy to offer up my card. For those of you online, if you go to our website, energysafety.ca.gov, all of our contact information is there, and we welcome making connections with you, especially with the tribes as a new department. We don't have a good contact list yet, and we are trying to build that list and really build the relationships. So welcome the ability to connect with you. Thank you.
We've got two online questions, and I'm happy to read them. Okay, so this is a question for the tribal panelists. First of all, thank you for your presentations. The question is, should the tribes consider moving to a franchise agreement model for purposes of internal ROWs, such as distribution lines and compensation? That's the question. Yeah.
So thank you for the question. Coming from the Hoopa tribe, this is something that we are considering. So with that, we talk about the resources that are needed. So you're going to need a specific energy attorney, to review those type of agreements and facilitate the negotiation. This is something that we will be bridging the conversation with PG&E to set up the franchise tax agreements that are necessary if, in fact, it is in the best interest of the tribe to benefit and provide resources. So absolutely, I think if it's a model that the tribe is going to benefit from, they should absolutely consider that.
Karen, do you have anything to add? You're good. Okay. I know, I'm like, I need, it's okay. All right, thank you. The next, exactly. All right, the next question we've got is a follow-up. Sorry, just a second. Okay, one area of concern is the applicability or lack thereof of the CPUC general orders related to pole attachments. What is the CPUC's position on whether these orders apply to easements on tribal lands since they are not applicable on government easements? Commissioner, do you want to take that one?
I'm not sure. I don't know. And I don't want to put Maria on the spot. If you or Michael have any more specific information as the closer to the subject matter experts. I know this is an issue we're examining right now, and I'm not sure that I have an exact answer for where we are, but it looks like Michael is able to respond. Oh, hold on just a second. I think Ken's coming with the microphone.
Michael Rosaire with Energy Division, CPUC. Commissioner, it's my understanding that those agreements are between the telecom companies and the IOUs, the energy IOUs. I'm not sure our exact jurisdiction over those agreements as a CPUC. Now, I'm not sure I understood the question exactly regarding right-of-way, but I'm not so, I don't know if right away is the issue. I think it's more the relationship between the telecom company that wants to utilize the existing support structures for telecom fiber deployment in agreement with, as underbilled to a power line, an electric power line. So I don't know if I've answered the question, but I think it's not. I think that it's a negotiation that occurs between the telecom company and the electric IOU.
And Amanda, do you want to reread the question just in case to make sure? 'Cause I'm not sure, maybe I didn't understand it as exactly either.
One area of concern is the applicability or lack thereof of the CPUC general orders related to pole attachments. What's the CPUC's position on whether these orders, the general orders, apply to easements on tribal lands?
And I'm not sure if part of that question is, I know we've had several companies talk to us about pole loading and that there's issues regarding that. And that is something between, as Michael said, but we're also taking a look at what that means for making sure we've got infrastructure to be able to ensure we're able to do our historic broadband build and what that means. So I think that's something we're looking at, and I don't know if Maria or Michael want to add anything there on specifically.
I know that there was a workshop held to discuss the different pole loading criteria that is part of the telecom corporation's application to the IOUs to use their poles. Other than that, I don't know. I think those agreements are largely between the telecom companies and the energy IOUs.
Sorry to chime in. So I just wanted to give a little bit of perspective we're speaking about tribal lands, right? So although we have poles, whether there be telephone or electric poles that are on tribal lands, some with an easement, some without. And so when we're thinking about different attachments, the company owners of said pole are allowing other companies to come in, attach to those poles without tribal consent, without compensation. So I think it's something, I'm just giving this as an idea of something to think about. Because tribes absolutely need to be involved in that, and they need to have their own right-of-way as well. So whether it's aerial, whether it's underground, it's still within tribal lands and tribal jurisdictions. So yes, pole loading, the insurance, all the things that are required, but it absolutely has to include the tribe. It is within our lands and within our jurisdiction. I'm not sure how that applies to the orders of the CPUC, but that is something that's happening as we speak.
Thank you. We have one last question online. This question is for Bernie. Are the policies and procedures the same when public utilities engage with tribal trust lands that are owned by allotment landowners, especially when they are fractionated allotment lands with many owners not managed by a tribe? Many allotment landowners have no power, internet in rural areas and are landlocked.
Follow up.
Yeah. Does anyone have a response to that one? Okay. Bernie, we may need to follow up with you offline.
Yeah, I guess maybe more generally, I don't know if any of the IOUs have anything to add to their prior presentations, if there's a different process or anything they do in addition when you're negotiating with an individual Native American landowner as opposed to the tribe for allotment land? Or is there?
I'll speak to the Rincon project because there is allotments there, but That discussion has not come up. It was just give us all the locations you want broadband to, and here's how much it's going to cost to deploy it to all locations you've identified. That was on the early stages, so we wouldn't know who owned those locations or if they're trust or allotment, but we will deliver it to all the locations that the tribe wants us to deliver it to. We don't see the difference there. Now, if they're not including those addresses, we wouldn't know if they're not including those addresses that are not owned by the tribe.
Yeah, and for Edison, we hold every residential. This is a resident, right? Not a business. We hold every residential account confidential, even from the tribe, unless it's emergency. So in this case, then they're not on the reservation. They're separate from the reservation, but they're a tribal member. They would be seen as another account, residential account that we would work directly with them, not with the tribe, and the tribe has nothing to do with that account. And we would work with them, by the way, so.
Okay, I think we're good.
Yeah, same here, same for AT&T. If there's a situation like that, then of course we want to provide service to anybody that wants service.
Thank you. All right. And with that, I don't think we have any more questions, so wrap up and conclusion of public session is next. Commissioner, do you want to?
Okay, just last opportunity for anyone online or in the room if you have a question. Okay, I'm not seeing any hands. Again, I want to thank all of the panelists and participants for the time, effort, and work to be here today. I've learned a lot. I think others in the room have as well. I hope everyone found the event today meaningful, and we do, in my conversations with Director Dutschke, hope to have some additional discussions on this, and we'll be reaching out to confer with all of the participants here on how best to do that on a regional level, and who the right people should be in the room. And we will be following up and looking to make sure that there's a process to get feedback and comments from all of the participants today that want to provide feedback into our relevant proceedings. I think that, the Commission's in a unique situation. We don't have direct authority over the right-of-ways. We don't issue them. We don't grant them. But right-of-ways obviously have implications for the utilities that we regulate to be able to provide services. They have implications for our engagement and government-to-government relationship with tribes across the state. And so this is an important issue, and we need to be working with our sister agencies on this issue, because that work also has impacts on what we all do here in our different capacities. And so I appreciate, again, all of the participation and engagement today, and really look forward to further discussions as we discuss. Oh, I cannot talk today. I think I'm now losing my voice. I really look forward to further discussions and meetings on this issue. I think this is just the beginning. There's obviously a lot of work that needs to be done, and I think we're going to be able to do that if we can keep everybody in the same room and continue the dialogue. Commissioner Gallardo?
I'll be quick. Just want to express my gratitude for everybody sharing their expertise, their commitment, and Energy Commission definitely looks forward to continuing being a good partner and engaging. And please let us know if there's anything else that we can do differently or better. We're always looking to improve as well. So again, thank you to my team for being here, and everybody else again. And thank you, Commissioner Houck, for the invitation.
Yeah, I'll just say I really appreciate the invitation. I really appreciate the discussion. When we started the Middle Mile Broadband Initiative back in 2021, we had to sit down and figure out a lot of this stuff out. And I was commenting to the commissioner, it would have been good to have something like this and a body of work to kind of start out, because we had to figure out piece by piece. And so as we can see, there's a lot of questions that needed to be answered, and just my team's, I had to learn a lot as we've gone through this, but it's a productive discussion, and it sounds to me like most tribes have, certainly similar interests in the utilities and in in facilitating, the benefits that these have, such as broadband would have to offer to the tribes. And similarly, they have a lot of the same challenges. And so, I think Michelle Lee was talking about the fact that there's a lot of that a lot of tribes don't necessarily have the resources to kind of plan for that. But I think these discussions really will help provide more of that background and more of that information, and hopefully kind of bring up the level of the overall level of knowledge as we move forward. So, thank you.
So again, thank you. And before we close the public session, I do want to have just the CPUC staff in the room raise their hand. I know we also have Judge Gao, who's the lead judge on our tribal OIR, who's here. Again, Ken Holbrook. We've got 2 advisors from my office, folks from Commissioner Baker's office, our staff from our different utility divisions. So again, I wanted to thank them for all the work in making today's workshop possible, and Yvonne, all of the work that you, Amy, and Kim did to make this possible. And of course, Joe, our IT team, who made it possible for all the folks online to be able to participate. And I'm really pleased to see that we've had such a great turnout. I'm not sure, what was the number for the folks online? We had 105 people online, so a lot of interest in the discussion today. The next part of the day, we wanted to give the tribal representatives that are here a chance to debrief and maybe make some recommendations on sort of next steps. I don't know, given the number of people we have online, if the tribes want to maybe have a part of that discussion with the utilities still in the room, and then just to talk about next steps a little bit, or if we want to go directly to having a government-to-government discussion just on what the tribes would like to see next. And I don't know, I'll look to some of the tribal representatives in the room. Okay. So maybe we'll just go to the next part with the tribal representatives, and then we'll circle back with the investor-owned utilities and meet with you also to get your thoughts on sort of next steps and where to go with the discussion, and really appreciate everyone's engagement today. So we'll maybe take a 10-minute break. Well, okay.